Well, good morning, everyone. It's just coming up to 9 o'clock. Welcome back to this hearing. And just for the people who are joining us today, my name is Dr. Lee Beattie, and I'm with Wendy Baker. We're the commissioners for the hearing, and welcome back to day two. So also we're ably assisted by Ms. Anderson. So as usual, all things go through Ms. Anderson. So what I'd just like to do, if I could, pass over to Ms. McDonald. If you could introduce all the people that you have with you in the room, in the virtual room today. And again, just like I said yesterday, especially for submitters, if your cat or dog or young child comes in the background, no problems whatsoever at all. We're all used to these sort of things on Zoom. So just picking up from where we are, Ms. McDonald, do you want to introduce which submitters you actually have with you today? And then we can go from there, and then I'll get the council to introduce themselves again, and we can go from there.
Sure. Thank you, Commissioner. I'm not sure, they're probably there somewhere in the heading bar, but I've got my experts, Ms. Tate and Dr. Trevathan. You may see pop up there some of the submitters whom I am representing today. Their intention in joining the Zoom meeting isn't to be speaking at the moment to their submissions, but they're joining just in case there might be something that needs to be added as we get through the evidence and hear the submitter's case.
Okay, so that's very helpful. So basically what we're basically just going to hear submissions from yourself and then from your two witnesses, and then potentially there may be some other comments coming in from the actual submitters, but as it stands at the moment, it's probably just going to be the three of you. So
yes, that's correct. Yeah.
Thank you. That's very, very helpful. So again, for any submitters, great to have you here. And if you're watching on live streaming, great to have you here as well. So before I go forward, is there anything anyone would like to bring to both Commissioner Baker and myself's attention before we start day two? Okay. Ms. O'Connor, would you just like to introduce yourself so that people can put a name to face in case any of the submitters are there? You there, Mary?
Good morning. I am Mary McConnell. I am a consultant planner to QLDC, and I am the author of the Section 42A report, which has been provided to the commissioners for their information. Later this afternoon, I will be appearing virtually with Mr. Hewland, Mr. Stiles, who will be speaking to Mr. Egerton's report, and Mr. Knott.
Thank you very much. Ms. Volt, would you like to introduce yourself there just for completeness, in case any of the submitters didn't see you yesterday? She may not be there. Okay, all right, we'll move on. The floor is yours, Ms. McDonald. We've received your submissions. Would you like to walk us through those?
Yes, I certainly would. So I've just started out there in my first paragraph identifying the submitters who I'm appearing for today. Just to make the point that the expert evidence that has been provided for the submitters includes the two people that Mr. Gresson was speaking for yesterday. So they're separately legally represented, but the expert evidence is on their behalf as well.
Thank you.
And of course, these submitters all lodged submissions opposing the application. And I've set out there the evidence. You'll hear from Dr. Trevathan and Ms. Tate. My executive summary. The proposal is one, I say, for an events venue, not temporary events, and as such, Chapter 35 has no application to the proposal. And I just want to pause here and just comment on some submissions that were made by my friend Ms. Walt yesterday, and it might be helpful if you had Chapter 35 before you.
Just bear with me for a second. I'll bring that up.
Ms. McDonald, are you talking us through I've got in front of me your legal submissions, but you're talking about an executive summary? Or should I have another document?
Oh, I'm at paragraph 4, which is under the heading executive summary. I haven't produced two sets.
I'll put that with you. Yes, that's all right. Thank you.
Oh, good. Just bear with me for a second. I'm just bringing the plan up online now. And I'm sure my colleague is doing exactly the same thing. Yeah. Yes, have chapter 30. Did you have that up, Ms. Baker? You have that up? Commissioner?
She's on mute.
I can see she's looking.
I've nearly got it up.
Well, oh, it doesn't. I've got it up. Have you got it up, Wendy?
Not just at the moment. Hang on. Okay, I'm good to go.
Okay, thank you. Yesterday, Ms. Walt referred to, or she used the term, I think, that the chapter temporary activities were exempt from other chapters of the plan. And I just want to make the point that rule page 35.3 of chapter 35, at rule 35.323, says that the rules in the chapter take precedence over. So there's quite a distinction in my submission from taking precedence over something to being exempt from compliance. And I say take precedence means that in the event that there's a conflict, the chapter 35 rules will take precedence. And just on that, just in support of that interpretation, at 35.3.1, the attention of the plan user is drawn to the fact that there are various district-wide chapters there that may apply. We then have the precedence rule, which is 35.323, and it says that those rules take precedence other than historic heritage or signage rules, which can prevail over the chapter 35 rules. But I think the telling thing towards the interpretation that I say is correct is rule 35.324. And it says, notwithstanding the take precedence rule, the rules in the chapter relating to temporary activities specify when the rules in chapter 36 noise do not apply. So if we were to follow the logic of Ms. Walt's argument that the chapter 35 or the temporary activities were exempt from all other rules in the plan, there wouldn't be any need for that rule 35.324. So I just want to make that point clear. It's not a great deal turns on it, I suppose. However, there are some matters related to Ms. McConnell's permitted baseline analysis and her application of the transport rules, for example, which Ms. Walt would say don't apply, but I say based on my interpretation they do. So that's just addressing that point. At paragraph 5, I say the proposal should be declined because the adverse effects on the environment will be more than minor. And in particular, the proposal will have unacceptable effects on amenity values. And I say the proposal is contrary to the objectives and policies of the PDP. The proposal will have an unacceptable effect on the submitter's amenity values. The combination of effects and use of the property as an events venue at the frequency proposed in such close proximity to the neighbours, and in particular here, 67 Speargrass Flat Road is inappropriate. And I say a grant of consent would create an undesirable precedent. The requirement in section 7C of the Act to have particular regard to the maintenance and enhancement of amenity values is particularly relevant to this proposal. Amenity values are defined in section 2 to mean those natural or physical qualities and characteristics of an area that contribute to people's appreciation of its pleasantness, aesthetic coherence, cultural and recreational attributes. Amenity values includes but goes far beyond matters of visual amenity. A key aspect, as I've said above, is the natural and physical qualities and characteristics of an area. In this case, the main audience you are concerned with is the present existing residents who live in close proximity to the application site, and in respect of whom an overwhelming number have submitted in opposition to this application. As discussed further in these submissions, the proposal falls short of maintaining and enhancing the amenity values of the site and surrounding environment because of the combination of adverse effects the proposal will generate for neighbours. There's no debate that we're dealing with a non-complying application, and I've set out there section 104D, which you'll be well familiar with. Ms. Tate discusses the policy framework from paragraph 90 of her evidence. The key objectives or consideration for the Wakatipu Basin Rural Amenity Zone are set out there, and she opines that on balance, the proposal is contrary to the policy framework of the PDP. And here I just comment that the submitters reject any proposition that Ms. Tate has cherry-picked the objectives and policies. A careful reading of her evidence reveals she has undertaken a thorough, fair and balanced assessment of the policy framework. The applicants in her, turning now to planning context and historic events, the applicant and her experts seem to place some reliance upon the historical use of the site for events outside of any permitted baseline analysis. The submitters wish to write the record so far as early use of the site is concerned. While events may have been taking place at the property since its purchase by the applicant in the early 1990s, such use has never been a complying one. In the early 90s, the QLDC was operating under a transitional district plan, which was prepared under the former Town and Country Planning Act. And that plan, and I footnoted there the ordinance that I refer to, which was included in the materials that I filed with my legal submissions. The TDP required an application to be made for temporary events. Have you got that before you, that ordinance?
So you've highlighted the appropriate section.
Yes, that's right. Well, first of all, I've highlighted there the rule that talks about uses that aren't specifically mentioned falling within the general class of use authorised. And then I've highlighted the temporary uses and structures. And over the page, there's reference to other temporary uses such as carnivals and bazaars. And giving the applicant the benefit of the doubt, I've said that, well, let's just say that weddings might sort of fall naturally perhaps within those types of other temporary uses. But the point I'm making is that the transitional plan required an application to be made for these types of temporary events. There's no record of any application being made. And the council's first generation plan was notified in October 95 and decisions made and released in stages in 1998. And that's now the operative district plan. So I say at least until the temporary events rule in the ODP became operative, sometime after 98, events that were operating on the application site were unlawful. There's never been any resource consent held for events at the application site. The council's never actively monitored compliance with the number of events held or with duration of events. And there's been little to no communication with neighbours as to when an event is being held or the usage of event days. And just on this point, I just want to turn to Mr. Giddens' amended conditions that were circulated yesterday, and his condition 21.
Just hold on for a second while we get our hands on that. Just hold on for a second. sorry, 21 was it?
Yes, and it's headed up operational management. It says no less than 48 hours prior to a temporary event that's intended to extend past 8 p.m. And he's got there a requirement to notify the list of property owners. I say that if consent is to be granted in some shape or form to events here, then a further check and balance should be to require notification to all submitters of any events that are to be held at the site, irrespective of what time of day they are to occur.
So can I just pause there for a moment? I'm just thinking about how that would take place. Just in your view, would that be, and of course, as you know, and Ms. Baker and I have come to any view, of course, but if that was to take place, would that be a letter or would an email be appropriate? How do you see the mechanics of the compliance of that taking place?
I think that an email in this day and age, certainly for all of the submitters that I'm representing, they do their business on email rather than a letter. And look, it may be, I'm presuming that if there are events here, they're pretty well booked in advance. Some might happen last minute, but whether that's the applicant or the consent holder, sending a fortnightly email or a monthly email saying, right, this is what's coming up. So I think that is just, as I said, another check and balance that's required in terms of compliance with these.
So almost like again, without any view, as you know, but it's almost like this is what's coming up for the next month of July, for instance, or what's coming up for September or October. That'd be a better way of thinking for the next month coming up.
That's right.
Okay, thank you. Sorry to interrupt you, Flo. Can you produce any questions on that?
Well, I'm just thinking 100 events. I don't know about you, but I get quite a lot of emails and quite a lot of them are unwanted. So it should be, you hear me now? You're not hearing me?
Yeah, you're phasing in and out there, sorry.
I might put headphones on. Can you hear me now? No.
Can hear you now, yes.
Can you hear me now?
Still phasing in and out a bit.
I'll put the headphones on. Carry on, question for later.
All right. Please box on, Ms. McDonald.
Yeah, thank you. And then just finally, in terms of context, the plan's limits on temporary events is not something that the applicant's only recently become aware of. I've just footnoted there a reference to Mr. Buckham's submission to the PDP in October 2015. I'll be coming back to this, but that was lodged some 7 years ago. And of course, the ODP has limited events to 7 per site, at least from some time in 98. So, this restriction isn't new or recent. It's been around for some time. What is the activity? And here, before I get into this, I note the discussion you had with Ms. Walt yesterday about this distinction between a temporary event versus an events venue or a commercial activity, maybe being a bit of a sideshow, but it is not a sideshow. I say to you that it is a fundamental part of your decision making to decide what the nature of this activity is, because whilst it's a non-complying activity and the effects are all relevant, the policy framework is another matter that's quite critical for your consideration, even if you determine it gets through that 104D test. So this is quite a relevant and important matter. The application is made on the basis consent is sought for temporary activities in excess of the rule at maximum 7 events per site. And by default, it falls to be considered still as a temporary activity that's not otherwise permitted. The submitters disagree with the applicant's interpretation of the rule framework and say that at the frequency proposed in particular, the proposal falls outside the definition of a temporary activity. The starting point is the definition. I've set that out there. And I say that the keywords there are short duration, limited frequency, and outside the regular day-to-day use of the site. I disagree with the interpretation advanced by Mr. Giddens and Ms. Walt yesterday, that once you make the list of specified temporary activities, the words in the definition, short duration, limited frequency, and outside the regular day-to-day use of the site no longer have any application. That is wrong as a matter of interpretation. The rule must be read as a whole, not broken into parts to suit. And at this point, I think it's of some relevance to refer to the Section 42A report and the hearings panel recommendation when it heard submissions on Chapter 35 of the PDP. And this was part of stage 1 of the review of the district plan. So it was the first series of chapters to be considered. The 42A report, when considering submissions on frequency, records that the council itself had made a corporate submission seeking that the frequency of temporary events enabled as a permitted activity be reduced from the 12 times that was notified originally down to 7. The reasoning provided is that 7 times is consistent, 7 events, is consistent with the temporary nature of events provided under the chapter. I accept this position as I consider that 1 event per month of potentially 6 days or more, including set up and pack down, is beyond the scope of a temporary event. So that was from the Section 42A author. The hearings panel considered a submission by Mr. Buckham, and his submission was to increase the number of events held at any site. And they said Mr. Buckham's submission sought to limit the period that temporary activities were exempt from zone noise standards to 0800 hours to 2000 hours and require compliance with noise standards outside of those hours, while extending the permitted evening hours from 8 p.m. till 12:30 a.m. He also sought to increase the frequency permitted to 24 per calendar year. Dealing with frequency first, we note Ms. Banks' comments that as notified, the rule could allow 6 days or more, including set up and pack down per month, and be beyond the scope of a temporary event. We agree that if a single site is used for events at that frequency and for that duration, it's not temporary. To double that, as Mr. Buckham seeks, could lead to half the working days each month being dedicated to such events. Now, I say that that passage is quite insightful, and that those involved in the ultimate end drafting of the PDP held the opinion that even at 12 events per site per year, the necessary element of temporary was lacking. Turning back to the PDP definition, activities of short duration, etc., these words serve to define what a temporary activity is and are cumulative in effect. For the purposes of use or uses of Thurlby domain to come within the definition of temporary activities as defined, then such proposed use or uses must not only be of short duration and outside the regular day-to-day use of the site, but also of limited frequency. As a matter of plan interpretation, the issue is whether on an objective reading of the PDP, 100 temporary events in a calendar year may amount to limited frequency of use of the subject site. It's apparent from Chapter 35 that the permitted frequency of a temporary activity is no more than 7 times in a calendar year, which is well short of 100 times. This is the level of change to amenity, 7 times, that is acceptable within a particular environment. Furthermore, the ordinary meaning of the words limited frequency suggests a temporary event activity is one that is few in number in any calendar year. Suffice it to say, 100 events in a calendar year is not few in number, particularly if one considers the majority of those events are likely to take place during the warmer months and not all year round. I did hear Mr. Buckham's evidence yesterday that the property is quite picturesque and during different seasons, and I accept that there may be winter weddings or autumn weddings, but I say that it's not unreasonable to expect that most of the events would take place during the warmer months, given the nature of the property and the condition of the buildings. Ms. Tate's evidence is that every day from November to April, events and activities associated with events could occur. Furthermore, events and activities associated with the same could occur 300 days of the year. And I just make the point there at the footnote that in that context, it's also strongly arguable that the regular day-to-day use of the site is for events. And there's nothing in the plan that suggests that there can only be one regular day-to-day use of the site. So it's feasible that regular day-to-day use could be the rural residential component the Buckham speak of, as well as events. The basic interpretive analysis undertaken above indicates the proposed use of Thurlby domain by the applicant would not amount to a temporary activity for the purposes of Chapter 35, because the use is not of limited frequency as required by the definition. And I refer here to a decision of the Environment Court in playground events, and I provided that with my submissions. And I say that that's of assistance to this interpretation issue. And I appreciate, of course, that every case does turn on its own facts and different definitions and different district plans, but there are some common aspects here. The basic facts in playground were that the applicant owned a small farm property located west of Hamilton and applied for resource consent to undertake 7 entertainment-related activities during the course of the year, 3 of which were prospectively came within the definition of temporary activities and were therefore permitted under the relevant proposed district plan. The application was a non-compliant activity 1, such as the case here. The potentially helpful and relevant extract from playground is as follows. We agree that the 3 temporary activities per annum permitted under the proposed plan set a level of change to amenity which is acceptable within this environment. But we do not agree this means that there is automatically a springboard effect on the bottom line the plan identifies as acceptable within this zone. We find that the description of the effects of the proposal as temporary and occasional to be incorrect. While the proposal may include some elements which could be called temporary in terms of the definitions used in the plans, the proposal as a whole is anything but temporary and has the potential to be the dominant use of the property for more than half of the year every year. Submitted that the court's decision or the conclusion, in the final sentence above is of near direct application to the application under consideration by you, and that while the present application may include some events which could be called temporary in terms of the definition, the Buckham proposal as a whole is anything but temporary and has the potential to be the dominant use of Thurlby domain for a period of around half a year every year, based on event days alone. Just turning now to the first limb of section 104D, and I just want to talk about the permitted baseline. Ms. Tate undertakes a comprehensive review of the permitted baseline in her evidence, and she expresses reservations about a simple doubling of the permitted activity events to account for the fact the applicant owns 2 sites. And I agree that such an exercise is fanciful, given the property is generally operated as a single site for the purposes of events, and in practical terms, both sites are used for events, whether that be for car parking, taking of photos, indoor, outdoor use for events. And just here, I do note that the applicant disputes this element of Ms. Tate's evidence, but about dual use, but I'm informed by the owners at 67 Speargrass Flat Road that the most recent event that took place on the property on the 22nd of August, which was a wedding, used both sites. The wedding took place in the stables, and then the wedding party and the guests proceeded over to the ruins for the photos. So I don't know how many times that happens in practice, but that's one example of both sites being utilised. Furthermore, it is somewhat disingenuous, I say, for the applicant to assert that on one hand, she and her family used the 2 sites effectively as one with the predominant rural residential use, yet then seeks to manipulate the permitted event rules by saying that the 2 sites should actually be separately accounted for. And the other matter that receives little comment from the applicant, and which is addressed further below in these submissions, is the consented boundary adjustment that's yet to be given effect to. And a plan of that boundary adjustment was included in the application that was notified. Are you familiar with that, Commissioners?
Which part of was that? Yes. Could you just remind us where that is again?
It's included with the in the application that was publicly notified, and I'm just
bringing up those. So that's the stuff I have. I'll just hang on for a sec.
So it should be the first part, well, the first chunk of pages in your agenda.
Yeah. Okay, just bear with me. Have you got that, Commissioner?
I know where it is, but I haven't quite found it yet.
Here we go.
I found it.
Yeah, just might be helpful to have that subdivision plan before you, so you can see what's proposed there.
I've got it before me.
Yes, all good. Please box on. Please proceed.
Are you hearing me, or are you not hearing?
No, we can hear you.
Oh.
So I say that this really doesn't receive much comment, and you'll see that the boundary adjustment has the effect of containing within Lot 2 seemingly all of the event locations that are the subject of this application, and the balance contains the Buckham dwelling and the rest of the property. Had this consent been implemented, and it's not clear why it hasn't, it was granted in February 21. Maybe it hasn't been implemented so that the applicant can maximise their permitted baseline assessment. But had it been implemented, the entire events venue would be contained within the one site. And with reference to Mr. Giddens' discussion of the permitted commercial recreation activities, so going back to paragraph 38, sorry, so the point I'm making there, I do come back to it again, this boundary adjustment is that if it had been implemented, that would have affected the applicant's permitted baseline argument, because all of the events venues within the one site, and we would be dealing with a 7 events maximum there. With reference to Mr. Giddens' discussion of the permitted commercial recreation activities that could be carried out on the site, I just note there that with a limitation of 12 persons per group, and that includes any guides or instructors, the intensity of use, I say, is not comparable to the intensity of use that's contemplated by the proposal, and the baseline analysis therefore doesn't really have any great utility as an appropriate comparison. I accept that it's a permitted activity, and it's not fanciful that those types of activities could occur, but I say it's not really providing much in the way of utility. Application of the permitted baseline, of course, is discretionary. I think, as was picked up during discussions yesterday, and I've referred there to the Littleton Harbour landscape case. I provided it with my submissions. It's the same case that Ms. Walt referred to in her submissions. The point there is that in addition to the well-known sort of discussion around permitted baseline and things being fanciful, the court expanded on some criteria that might assist in determining whether the permitted baseline test should be used, and that's at paragraph 21 of that decision. And that's not an exhaustive list, but they were just some matters that the court thought could assist in making a determination. And while these criteria aren't tests, nor are they exhaustive, they go to the single question of whether it's possible and sensible to embark on a comparison, or whether there would be a notional, or even whether that would be a notional or fanciful exercise. One of the criteria that was identified in that decision was whether the permitted activity with which the proposal might be compared as to adverse effects was nevertheless so different in kind and purpose within the plan's framework that the baseline ought not be invoked. And I say that there are elements of that here. Where here we have 2 sites, each capable of use for 7 events. Yet the sites are located adjacent to each other, and I say to all intents and purposes as one for events, and are singularly known as one event's venue, Philby Domain. I submit that the plan's framework didn't contemplate the scenario that we really have now of 2 sites side by side, being able to maximise events, you know, from 7 to 14, and it's quite an unusual and I submit unexpected consequence of the definition of site that we have in the plan. So in my submission and in all the circumstances of this case, you ought to exercise your discretion and apply the baseline to a limited degree only, that being to 1 site and a limit of 7 temporary events per site. Turning to adverse effects, these are addressed comprehensively by Ms. Tate. She finds, with respect to effects on landscape character, effects are within the minor threshold based on the intensive and persistent nature of the non-residential activities that could occur on the site, and the semi-permanent buildings and facilities likely to be present for a noticeable portion of the year. With respect to noise effects, there are information gaps which have been filled, and to some extent, Mr. Trevathan will talk further to that, although it appears noise effects of themselves are generally acceptable. With respect to heritage values, there's no commitment by the applicant to reinvest funds from events into maintenance and upkeep of the buildings. Appears some buildings are unsafe for use, and I defer there to the evidence yesterday, which suggested that those that are going to be used for events are not unsafe. With respect to traffic effects, effects are less than minor, but again, more information had been sought, and that appears to have been provided by Mr. Bartlett yesterday. Servicing effects, the temporary nature of services diminishes the overall amenity of the area. And cumulative effects of the proposal, combined with the temporary filming activities, are a relevant consideration. And cumulative effects of intensity of use of the site are more than minor in terms of the site, the total saturation of the site with non-residential uses. And on this point yesterday, you asked Ms. Walt to provide you with the 2 cases referred to in her legal submissions when she told you that there was still a degree of uncertainty about the extent to which permitted activities could form the basis for a cumulative effects assessment. And she provided you with the case of Dye, which was a Court of Appeal decision, and she provided you with a copy of a case of Judge Jackson's, which showed a divergence of opinion. There's another case, it's called the Outstanding Landscape Protection Society Incorporated. I had a look at that last night, and it adopts the same position as Judge Jackson, which essentially, first of all, and I think quite significantly to distinguish Dye, which is a higher authority but an older case, Dye was decided before the Hawthorne QLDC case, so I think that's quite relevant in terms of its limited application. But the court in the outstanding landscape case, echoing the same comments in the decision from Judge Jackson, says there's a passage in the Court of Appeal's judgment in Dye which, taken literally, appears to hold that cumulative effect can only be one that arises from the proposed activity itself. All of these are effects which are going to happen as a result of the activity which is under consideration. The consequence of that would be that only adverse effects emanating from the proposal itself could be brought into account. There could be no cumulative effects, properly so called, created by combining existing or permitted effects with effects arising from the proposal. In turn, that would mean that so long as the adverse effects of the proposed activity are not of themselves more than minor, a consent authority could never say, this site has reached saturation point, it can take no more. And the court says that interpretation would, we think, be contrary to the plain meaning of effect in section 3. If a consent authority could never refuse consent on the basis that the current proposal is the straw that will break the camel's back, sustainable management is immediately imperiled. Anyway, and I can send you that relevant part of that decision. But essentially what I'm saying is that cumulative effects here are relevant in the context of your consideration of both the effects generated by permitted activities, including filming activities, as well as the effects that will be generated by the proposal for which consent is being sought. Amenity values, top of page 11. The sum of effects combined with, this is Ms. Tate's findings, the sum of effects combined will result in more than minor effects on amenity values. And I've just made a footnote there to the AFCO decision that unless all effects, positive and negative, are considered together, the balancing of them may be distorted, or incomplete. So I'm saying that you need to consider all of the effects together. You can't just consider whether some effects outweigh the others. It's a matter of considering all of the effects in the round. The persistent effect of noise generated by the proposal has not been sufficiently acknowledged or assessed by either Mr. Giddens or Mr. Hay. Permitted noise does not mean no noise. Noise will still be audible. Noise from the operation of an events venue in a rural area is outside the character of the area. The proposal seeks to authorise persistent and intensive non-residential use of the site for at least 6 months of the year. The practicalities of servicing events will result in adverse effects that are more than minor, as will the effects of temporary structures. And she finds that the proposal sits outside the existing character and amenity of the area. Just with respect to compliance with noise standards, I've cited and provided a case there, which is Mobil Oil New Zealand and Taupo District Council. And that case concerned the operation of a service station in a residential area. And the judge there observed that, Judge Bollard, I think it was from memory, that the test is not whether the plan's noise levels are met, but are the potential adverse effects of noise going to detract from the amenity of the neighbourhood, and will noise be reasonable? Just turning now to talk about 67 Speargrass Flat Road under this effects discussion. And I do acknowledge the changes that were made and notified to us yesterday, that for outdoor area 1 there's going to be a reduction in the days and number of people that can use that part of the site. But my submission still remains that there is no need for events to take place here. Even with the amended conditions, the wall is still required to mitigate effects. This is one of those cases, I submit, where the mitigation itself creates an adverse effect which is almost more unacceptable than the noise that it's trying to mitigate. As you will have observed, the dwelling on the site is located just 20 metres from the boundary of the application site. The amenity effects on the owners of 67 are twofold: the construction of a 2 metre high wall to block them and the events venue out, yet still bearing the effect of the presence of persistent activity on their boundary. Ms. Tate, in her evidence, doesn't support outdoor events in either Area 1 or the stables, as use of these will have more than minor effects on the amenity values of 67 Speargrass Flat Road. Just turning to visual amenity and heritage effects, the proposal will result in adverse visual amenity effects and effects on heritage values that are not less than minor. In particular, the assessment provided by Mr. Brown and attached to the evidence of Ms. Tate is that there is potential for significant adverse effects depending on how the proposed acoustic wall is constructed. Mr. Brown's assessment is that the construction of a solid 2-metre high and 50-metre long wall on the boundary will still result in a minor impact on the visual interrelationship between the stables, the cow byre, and Ron Gordon's homestead. His assessment is to the effect that the historical relationship is a relevant period of interest, albeit more recently, but still a relevant period of interest in the history of the site. And it is mentioned specifically, although briefly, in the HNZ listing documentation, and that's the document attached to Mrs. Buckham's evidence. And just on this point, a couple of things. I can confirm that it was Mr. Gordon who indeed did install the cattle stop, and he used that as the entry point from to access the stables and cow byre. But in terms of the Heritage New Zealand account of Thurlby Domain, I think it's particularly unfair and actually quite unfounded for my friend yesterday to refer to the Gordon era as the dark period. I think if you read that carefully, the wording is that the glory of Thurlby Domain had departed long before Mr. Gordon took ownership. Just in going back to my paragraph 48, the photographs that Mr. Brown has included in his assessment illustrate the open nature of the site, showing the strong visual connection between the Gordon homestead and the stables and the cow byre buildings. Mr. Brown is critical the applicant has not provided drawings or visual images to demonstrate how this interrelationship, as well as the visible aspects of the site from the public realm, will be affected by the proposed wall. In his assessment, the key view where the relationship will be affected in terms of the public realm is from opposite the entrance of 67, looking towards the stables. In Mr. Knott's peer review, he discusses key views of the proposed wall when approaching from the northeast across 67, including through the driveway entrance to this property. He observes that as the wall will be viewed in the context of the stables from this direction, he considers a condition should be added to the consent to require additional planting along this boundary to close gaps in the existing hedge to ensure that the wall does not appear dominant in any views from the road in this direction. The report from Origin, when addressing the acoustic fence, notes that there is vegetation lining the road frontage of the neighbouring property at 67, which will conceal the fence, and only glimpses of it are likely to be seen travelling along the road from the east. The Origin report concludes that given these factors, it's anticipated that the fence will not adversely impact any of the heritage values or the heritage significance of the buildings or the extent of place. Mr. Knott says he agrees in part with that statement, and that on his site visit he saw, as set out in the report, that there would be some views of the fence when approaching from the northeast across 67, including through the driveway. And as above, he has a recommendation about planting along this boundary. With respect to Mr. Knott's recommendation and the observations of the Origin report, I make two comments. First and fundamentally, the vegetation that the Origin report refers to as providing existing screening along the road frontage of the neighbouring property at 67 is not vegetation that is within or under the control of the applicant. As such, it can't be relied upon to provide any screening function. As regards to the additional planting along the boundary to fill gaps, it's not really clear where he intends this to be, but if it's along the road, along the frontage of 67, which would accord with the photos in Mr. Brown's assessment, the planting in this location is not something that's within the control of the applicant, and I submit it can't be conditioned. On this basis, I question the effects findings with respect to the location and erection of this fence on the public realm and sense of place, and I think that is a matter that needs to be readdressed by both Origin and Mr. Knott in terms of the reliance on that planting and what happens if it's not there. Turning to the second part of 104D, as above, the policy frameworks comprehensively addressed by Ms. Tate. In summary, she finds that so far as these strategic directions policies are concerned, the proposal is a visitor industry, but not well designed or appropriately located. The proposal is contrary to the relevant Chapter 24 policy framework, and that noise arising from the proposal is unreasonable and inconsistent with the relevant policy framework in Chapter 36. She says overall, proposal is contrary to the objectives and policies of the PDP. Now I just want to turn to what I call a disconnect between the applicant's evidence and the application per se, and I think this was sort of teased out a bit in some of the questions you asked yesterday in the discussion. The proposal has been subject to continuous change from the time it was first lodged, and the experts for the submitters have struggled to understand the exact nature of the proposal and the full extent of the conditions proposed. On the eve of the hearing, there was no final full set of conditions to be found anywhere in the applicant's evidence, and we were presented with them quite an extensive a modification of those on the morning of the hearing. This has been both frustrating and a source of ongoing uncertainty for the submitters, in part due to the extent to which the proposal relies on the implementation of various controls and management plans to manage and mitigate adverse effects. This is also discussed in Ms. Tate's evidence, and she'll comment on these revised conditions as well, as will Dr. Trevathan. And she expresses her concerns about the enforceability and practicality of conditions. Ms. Tate observes the amendments to the application canvassed in the evidence have not been confirmed by way of a set of updated conditions. I think I can leave that there. The criticisms, we've got revised conditions which supposedly now address these matters, and we'll go through those. With respect to Mrs. Buckham's more active role, the submitters are concerned that upon implementation of the boundary adjustment, that the events venue will be separately titled and capable of either sale or long-term lease. The submitters question how the boundary adjustment scenario, assuming it's going to be given effect to, accommodates an effective management and control function between two separate titles capable of independent ownership. The applicant's assurances, which I say are yet to be transformed into a workable and enforceable condition, rely on the applicant's ownership of the events venue in toto. The applicant needs to address her assurance as to management and control in the event of separate ownership of the two sites, either as is, they can be sold independently now, or post the boundary adjustment scenario where lot 2 contains the complete events venue. If one or both properties change hands, one questions how these controls will be given effect to or be meaningful. There's no offer by the applicant, for example, to ensure that at all times the events venue is under her ownership, management and control. Mrs. Buckham seems to acknowledge that this is an important component of the proposal to increase events. I refer there to her paragraph 34H, where she says, I acknowledge and accept that this is being especially necessary if events are to increase as we propose. Yet again, the submitters are concerned that if the events venue is separately titled and it changes hands, the applicant's offer of on-site management and taking a more active role will mean little. Mrs. Buckham's evidence lists various interests she's received in the property, and I won't read that out. That was summarised again by them yesterday. I do say that the selection of events are relatively low key. Some on the face appear to be permitted activities, for example, members of historical families visiting or school parties visiting the site, cycling, walking groups. The types of events described in Mrs. Buckham's evidence are significantly less intensity and scale than the outer limits of the proposed conditions prescribed in the application. There appears to be a fundamental disconnect between the two. And indeed, this was reinforced in her summary statement of evidence yesterday, where she said they have no intention to host 100 events at the property, all with 150 guests with full catering and services. Yet, as you correctly identified yesterday, this is what the consent would allow. And Ms. Tate is then criticised for assessing the consented scenario being utilised to its full parameters by the applicant's legal counsel and her experts. And I say here, Commissioners, there's little wonder that the near neighbours have submitted so strongly in opposition to this application. Its metes and bounds are well beyond that which the neighbours submitters wish to see established in their neighbourhood. And the fact the applicant seems to be singing off the same song sheet, but yet continues to promote the full extent of operating limits is quite baffling, to say the least. When one considers the evidence before the panel, particularly that of the applicant and the disconnect described above, it's apparent in my submission there's been insufficient care and detail crafting the proposal and its conditions to marry up with the types of events the applicant says she has received interest for, and for which one assumes has led to this application being made. And I just want to make a point there that the applicant mentions on numerous occasions that it's not her motivation to establish a commercial operation on this site. And just on this point, commercial and revenue received, there's discussion yesterday about the applicant not being willing to commit to a condition to invest funds into maintenance and repairs of the heritage buildings. And while Ms Tate will take that up further in terms of her recommended conditions, I just want to comment about Mrs Buckham's evidence of the cost of repairs being in the order of $40,000 to $50,000 per annum. And I'm sure here that Ms Walt will correct me if I'm wrong, but my understanding, having seen a hire agreement for Thirlby Domain, and I saw that attached to a marquee building consent application made in 2020 on eDocs, is that the daily hire fee for the domain is $3,750 per day or part day. So at 14 events per annum, that's $52,500. So I just make the point that even at operating in accordance with the permitted activity rules, there appears to be sufficient income generated to meet that cost, and that doesn't take into account further revenue that might be gained from the hiring of the property for filming activities. Nearly done for me. Part two, just considering the above, the proposal will not meet the purpose of the Act. And fundamentally, again, it won't achieve Section 7C, being the maintenance and enhancement of amenity values due to the numerous adverse effects on the amenity of neighbours. Just turning to address a couple of other matters, consents that are required but not applied for. I say as Chapter 35 has no relevance, the applicant can't rely on the provision related to the sale and supply of alcohol not being regulated by the district plan. And I think that's another reason why, the determination as to what type of activity this is important, so the applicant knows what consents they need to get going forward. The sale and supply of liquor is a non-complying activity in the Wakatipu Basin Rural Amenity Zone. And I've footnoted the rule there, which is the one that has non-specified activities defaulting to non-complying, which would capture the sale of alcohol. And no consents have been sought for the portaloos or the marquees within the heritage sense of place. These are buildings by definition. And in terms of the sense of place, development means new buildings and structures, and new I'm interpreting there to mean something that is new in terms of being brought onto the site, and the definitions in the plan, which are detailed in Ms Tate's evidence, capture buildings because it refers to the Building Act definition being temporary or permanent, movable or immovable. The only exemption is if the buildings aren't a structure as defined, and structure as defined in the district plan is anything anything that's under 2 metres in height or less than 5 metres square in area. I did a bit of research. Your standard portaloos about 2.8 2 metres in height, and I would submit that a marquee is going to be over the 5 metre square threshold there in that definition. So no consents have been sought for those buildings as part of this application. Site visit to 67, you've covered that off. The final thing I just want to address with you is the conditions that have been proposed by the applicant. Ms. Tate and Mr. Trevathan will offer some further comments on those from their respective expert perspectives. But in general, in my submissions, the conditions are numerous, they're complex, and they put an increased onus on the council to monitor and enforce post-consent being granted, rather than actually determining through the consent process as is required how practical and appropriate those conditions are and whether they will actually manage adverse effects to any acceptable degree. And they don't lend themselves easily to the scenario posed by you yesterday, Commissioner Beattie, of the hiring of a local hall where you're given the keys, off you go, and when you finish, lock the door and turn off the light behind you. These conditions are complicated. They relate to 5 different areas of the site and all have differing requirements. So it's not quite as simple as hiring out the community hall. Anyway, those are my legal submissions, and I'm more than happy to answer any questions you may have of me.
Thank you very much, Ms. McDonald. Commissioner?
Hopefully you can hear me better now.
Yes,
I've moved computers and changed all sorts of stuff. So my first question actually goes back to the last thing you said about the sale and supply of alcohol defaulting to the non-complying status as it's an activity not listed. Now, this is obviously a bit of an issue which goes to the matter which has been dealt with recently in the Waterfall decision, in my opinion, in that, is that an activity in its own right? Or is it actually part of an activity like a commercial activity in this case? I'm not sure. Maybe you could comment on that.
I would say it's an activity in its own right, only because that's how it's dealt with in other parts of the plan. So in the town centre zones, for example, you have to get a resource consent for the sale and supply of alcohol. And that's over and above it being part of a commercial activity, which might be a restaurant, for example.
Okay. Now, earlier on, you commented that you would like to see all submitters notified of all events. And you've also commented that 100 events is quite a lot.
Well, yes.
I'm just not sure that the submitters really want to be notified. You know, you're speaking for a group of submitters who I think are listed or potentially your submitters, but all other submitters may not wish to be notified. There needs to be a degree of what people want.
Yes. But Mr. Giddens might, or I'm sure the applicant will be able to clarify in their reply. My understanding is that the list of submitters and the condition are they're certainly the group. I don't know what additional submitters are in there over and above the ones I'm acting for. My comment was in the context that if consent is granted in some shape or form, so I accept that at one extreme that could be 100 events, and at another it might be something that's significantly less. But the point was that it's a check and balance to ensure that there is compliance with the conditions, and that it's just, as I said, who's going to monitor how many events are out there? You know, it's just another way for the submitters to have an appreciation of what's going on. And 100 events, whether that means that there would be 100 individual emails, or whether it means that there would be a fortnightly or monthly email that is sent to submitters, I don't know, but
okay.
yeah.
Okay. the permitted baseline I just wanted to go through with you. I know you've said that, or you've submitted that you consider it unfair for this to be considered as 2 sites. And I take that point that you're making, but the permitted baseline is for 7 events of 3 days duration with, as far as I can tell, an unlimited pack up, pack down time.
Yes, that's one. Yes, but I believe that that's quite fanciful, and that's never happened to my knowledge on this site before. Certainly, that's certainly not the experience of any of the submitters that I act for.
So your submission is that that's a fanciful scenario.
Yes.
Okay. Okay. I don't think I have any further questions for you, Ms. McDonald. Thank you.
Just bear with me while I just go through again. I think it's very comprehensive what you're saying, and no, I understand everything you're saying. Thank you very much. Thanks very much for your submissions. Thank you very much. Very helpful.
Thank you. So I think we'll hear from Dr. Trevathan next.
So has Dr. Trevathan and Ms. Tate got a executive summary like we had from Mrs. Volt's witnesses, or are they just going to read something out to us? What's proposed there? Because we haven't received anything else.
Sure, they don't have executive summaries. They are going to read something out. More than happy to arrange for those notes that they might have to be provided to you if that would assist.
I think that would be very beneficial for myself and my colleague if we could just do that. And that way, I appreciate that we're all being recorded and it's all on and such like, but it would just be helpful if that goes into the records as well. So thank you for that kind offer.
Yeah, sure.
Dr. Trevathan, sorry, my apologies.
Good morning.
Morning. You're in the office at Christchurch, are you?
Yes, yeah, no, that's right. Looking out at the Christchurch Council building. So. Yes, as Ms. McDonald alluded to, I've just got some comments on Mr. Hayes' summary from yesterday. So if you have that handy, because I'll refer to that sort of by paragraph.
Bear with me for a second. So my fellow commissioner and I can get our hands on those. They are here. Yes, I have those. Do you have those, Commissioner Baker?
Just gathering them, having moved rooms. I'm a little bit
You need to reorganize.
No, yes, I do. When we after Mr. Trevathan, I might request a 5-minute break, Mr. Fellow Commissioner.
Well, do you want to have a? Shall we?
No, I found Mr. Hayes' summary, and I have Mr. Trevathan's evidence, so I think I'm ready to go. Thank you.
Because I think after Dr. Trevathan, we'll probably move on. We'll probably go for the break then as well.
Thank you.
Okay. Thank you. Over to you, sir.
Cool, thank you. So I guess just working through a few comments in paragraph order. The first one was on Mr. Hayes' paragraph 11, where he states that daytime use will comply with the proposed plan limits. I guess I just noted, as you did yesterday, that the applicant's new condition 19 wasn't actually consistent with that and would require amendment to refer to the property boundaries for the lifestyle precinct.
I think they agreed to that.
Yeah. Moving to his paragraph 28, which is talking about nighttime events. I guess just noting that it contained the slightly unexpected statement that the predicted noise levels are only marginally above the applicable guidance for sleep amenity at 4 dwellings. So I had understood that the situation was that nighttime noise would exceed the district plan 40 decibel limit at some site and notional boundaries, but wouldn't exceed the 45 guideline for sleep protection guidance from the World Health Organization, for example. And so that's consistent with the last predictions from Mr. Hay, which are in table 2 of his evidence, where there's a receiver expected to receive 41 decibels, one at 45, a 42 and a 43. Whereas that statement reads as if levels of over 45 are now expected at dwellings. So perhaps it's just something to clarify in the reply, that whether it's just a typographical error or or what he was alluding to there. Moving on to Mr. Hayes, paragraph 35. So he works through filling in some of the, or providing some of the additional information I'd asked for, which is great, around the red barn modelling and predictions. I guess just noting, I'd also raise the issue of expected noise levels and effects from vehicles leaving events at the end of the night, and that wasn't something that he returned to in the summary. On the red barn measurements and predictions, so Mr. Hayes clarified that he's measured the sound reduction that the barn provides when it's got the doors closed. And I guess a few points on that. I'm still cautious about the doors closed assumption when you've got a non-temperature controlled, non-ventilated space being used for dancing. So my experience is that with a purpose-built facility, the space gets humid and it heats up, and those are important issues to be addressed. And also, I guess, from a practical point of view, where the bathrooms are external to the building and you've got 150 people, I'm not sure that the default assumption that the doors are closed is a safe one. Second point on that, Mr. Hay refers to both doors, so there's one in the north facade and one in the east, as standard personnel or access doors. I'm happy to be corrected, but the photos and discussion photos from my colleague Mr. Hutchison, who visited the site of the building, and my discussions with him, building that he understood to be the red barn, the door on the eastern side is a large sliding door. I think colloquially you would call it a barn door, so it's on sliders. So it is a large door, and that's the door that faces out to area 2 and would be the key one for those receivers 5, 6 and 7 in that southeastern direction. Third point in his paragraph 37, Mr. Hay goes on to say that he's done some further analysis, and leaving the doors open would have imperceptible effect on received noise level. I guess some more precision there would be helpful, because as you may know, in acoustic engineer speak, an imperceptible change in noise levels is potentially talking about a 1 or 2 decibel noise level difference, which may well be realistic. But I think the point is at receiver 6, the predicted level with the door closed was already right on the 45, which is now proposed as a limit. And so even if it's a small imperceptible change in terms of the limits that have now been volunteered, if we're now talking 46 or 47 decibels, then I suppose now that there's actual noise limits proposed and noise monitoring, you could say that sort of thing will come out in the wash. You'll go do the noise monitoring. If it is 46 or 47, then you'll work through with the noise management plan what the strategy is to reduce the level further. I guess the issue here is that the most obvious thing to do would be to reduce the internal music noise level from the 90 that's been discussed to do something less. But we've already sort of been around that loop with the original Tonkin and Taylor assumptions, which seem to be widely agreed were too low for that type of activity. And so if you're talking about reducing the 90, back towards the 85 Tonkin and Taylor had originally assumed, then you're back in the situation where that will be a level that will be constant pressure from people attending events to increase if it's supposed to be dance music. So it's just where does all that lead you to, compared to a situation of a purpose-built venue for this type of thing that had the cooling and the ventilation and had a sound lobby so people could get in and out, and would allow for an internal music level which was suitable for dancing. It has got a different sort of complexion, I suppose, in terms of is it trying to fit a round peg in a square hole, where some of these things are only just all hanging together. Moving on to paragraph 44, which relates to these late night events as well. Mr. Hay mentions the latest proposed conditions providing some sort of respite on weekends. And that's a concept that doesn't seem to have actually made it through into the latest proposed condition 6. It doesn't mention weekends, so I'd be interested to understand what was actually being considered or proposed there. What I'd suggested in my evidence essentially equated to, in terms of respite, if there was a weekend late night event, that the weekend before and after wouldn't have an event. And then paragraph 46, which was around the 6-hour time limit for events. And I guess now looking again at the specific conditions actually proposed by the applicant, condition 4C, the situation seems, I guess, worse than I was anticipating. So it seems to be accepted that there's no restriction. You can have 2 events on one day as long as they're not simultaneous. They can be in series. And then condition 4C limits any event to 6 hours. So if I'm reading it correctly, you could have 2 6-hour events, or a 6-hour event and a 2-hour event on the same day. And from a noise point of view, at the technical end of things, Mr. Hayes subtracted 3 decibels from his predictions on the assumption that event noise will only occur for half of the daytime period, which is 6 hours. So that outcome wouldn't be ensured by those conditions. I suppose otherwise there's some matters which I raised which Mr. Hay hasn't responded to, but there are some changes in the conditions which are worth noting. In terms of the potentially confusing array of background level requirements for the different parts of the site. This is for music. There's a new table that's appeared at the end of condition 10, which sets out 3 different possible background levels and what that means quantitatively and qualitatively. I see Commissioner Beattie, you have the conditions in front of you. So I guess perhaps this table, illustrates my point as much as anything in the qualitative descriptor column, which is the right-hand one. Outdoor areas 1 and 2, which is the top row, and the stables, which is the bottom, have the same qualitative description, even though the noise level is different. It is 10 decibels different, which is half or twice as loud. So I guess what I was really getting at with that point is that if the stables is so marginal for accommodating music at all, it would be much simpler if there was no music at the stables, and then the other 3 areas all had the same restriction, which was the 65 at 10 metres, which isn't particularly different to the slightly higher ruins level at the moment, which just adds a layer of complexity. In that same condition 10, there's still the chopping and changing terminology with speech versus music. So that latest condition 10 only mentions speech under the farm building. So I assume that's deliberate, and that is what's being proposed. On the PA system for the Red Barn, there was no discussion in the part of the hearing that I heard yesterday on hiring a system versus a permanent PA, but there's a new condition 17 which requires the use of an in-house system in the red barn, apart from fire exemption by quite a difficult pathway, which addresses the concerns I had about hired systems being brought in, but hasn't responded to the issue, again, I guess because of the unique facility, whether that system will be physically permanently installed or whether it's still packed in and packed out for each event, and so isn't as controlled as a normal system, which is set in place, calibrated, locked and left. And condition 20, which has now appeared, as I alluded to, with noise monitoring, which requires monitoring within the first 3 months of events commencing. And I guess my point was that if I've understood what's proposed in terms of event management, that events could have a whole discrete set of people involved, the event manager, the people running the equipment, the catering staff. And so how does a positive outcome from monitoring at one event provide you with any knowledge as to how future events may unfold? Happy to answer questions.
Thank you very much for that. Commissioner, do you have any questions for this witness?
Yes, I do. Thank you, Dr. Strathen. Firstly, that final condition 20, which you were just commenting on.
Yes.
So you had some criticism of it, and I probably had similar criticism expressed slightly less eloquently earlier on. How, though, when you have such a diverse set of potential events, do you undertake monitoring without actually monitoring every single event?
Yeah, I guess the quick answer is I'm not sure. That's as Mr. Hay acknowledged in his summary, this is a uniquely complex situation, and that seems to be one of the challenges that it's thrown up. So I think, monitoring in perpetuity isn't practical. Having a common element, a strong common element to the management of the events potentially is the more practical way to, so there is some common thread in terms of personnel that runs through all that. So feedback and learnings from past events actually get implemented, and you're not going through being controlled by feedback from the neighbours and complaints sort of situation.
Sure. Okay. The condition which has the qualitative noise descriptors in it, I was quite interested in that too, and I'm glad you've raised that. Obviously, you've picked up some issues with it, but as a condition, how would that work? Would you have an and? You'd have, and you've got to be below 65 dB, and at 10 meters from the speaker, the conversation has to be able to be had. Is that it seems to me that qualitative descriptor is unenforceable anyway, even if you weren't concerned with what they actually say.
Yes, yeah, and again, I don't think I know the answer, but yeah, in terms of how that table fits with the tests that conditions are supposed to pass, etc.
But if we struck out the qualitative descriptor, you'd have no concern with the condition per se.
No, well then you could go measure and have an answer to that. Yeah.
Okay. I don't think I have any further questions for you. Thank you very much.
I'd just like to pick up this point that I picked up just in fairness about this, going back to that World Health Standard and the idea of moderate, and how is that a conventional viewpoint that given the way that scale works, that if it's moderate, it falls within that less than minor space? Is that sort of a convention within the noise world, if you like, for better uses of words?
No, I don't think we're on the same page with enough to. So I think it's reasonably complex because there's a few different ideas intertwined there. Because the context will be different in different situations, whether you have a district plan which has a limit of 50 or 55. And often where the acoustic engineers are getting asked that question in the context of a notification decision, so less than minor versus minor. And so the what people in the area might have reasonably expected based on what the district plan limit kind of becomes a thread and all of that. Are we really going to not notify something that exceeds our limit in our plan, or notify something that complies with it? I did look up, following the discussion you had with Mr. Hay, what the actual World Health Organization wording around the 50 is, because I thought you might be interested in that. So the wording around 50, which, as Mr. Hay said, is a 16-hour average over the whole daytime. And it describes 50 as during daytime, few people are moderately annoyed at LAEQ levels below 50. Or in another place, to protect the majority of people from being moderately annoyed during the daytime, the outdoor sound level should not exceed 50 dB LAEQ. So I guess in terms of RMA language, less than minor and minor, often being below 50 and less than minor would be sort of intertwined somehow, along with the logic that if your district plan limit is 50 and an activity has levels less than that, perhaps it's not appropriate to notify it on the basis of noise. And then it's when you're in that space between 50 and 55 and above that it really always starts to depend on as it should, on the circumstances, the character of the noise, and the ambient environment, and the receiver's sensitivity.
So, I mean, from your point of view, I suppose it's more of a heritage thing, but from your point of view, a wall could be constructed to achieve the outcome that's sought here, can't it? It'd be just the question of its design, wouldn't it?
That's right.
Yeah, and it's just the impact of it. Okay, thank you. I thought you'd say that.
I agreed with Mr. Hay when he described the wall as being only looking at it for activity in outdoor area 1, just because of the sort of geometry, as he explained, of the site layout, etc. That's why the wall is required outdoor area 1. Yeah.
Okay, thank you.
I do have one more. Sorry.
Certainly.
Can I just have one more question? Dr. Trevathan, you said about multiple events, and if there were to be more than one event on one day, then the deduction that Mr. Hay had applied to his sound levels would not be valid. And I understand that. Does that mean that we would add up to 3 dB to each of the values in his tables? Because I understand that's how much he had deducted.
Yes, off the top of my head, that will be his table 1, which is this is a daytime issue where the duration apply. So yes, off the top of my head, that would be correct.
So would that result in breaches?
So just looking at it here, there's a 48 under Red Barn receiver 11, which receiver 11. Oh yeah, receiver 11 is that corner of.
It's the boundary site across the road, yeah.
Yes, yeah, where the limit applies at the boundary. So that does look like that would be 51. So that would require, I suppose, the other assumptions which underlie his predictions to have been present in on that day. So that would be both events happened at the Red Barn at the levels he's assumed. Then yes.
Okay, thank you.
Thank you very much for your time. I think that brings us round to quite an appropriate place to have a break. shall we have a 15-minute break, and we'll come back at 11:45, and we'll go to Ms. Tate. Thank you very much. We'll stand adjourned until 11:45.
Thank you.
Thank you. All right. Welcome back, everyone. Hope everyone's had a chance to have a cup of tea and such like. So, on to Ms. Tate, is it now?
Yes, thank you, sir.
Thank you very much. Good morning, Ms. Tate. Morena, how are you?
Good morning, Commissioners. Can you hear me? I haven't had to
Yes, all
test my
good.
microphone yet.
That's all
Good
good.
morning.
Commissioner Baker has fixed her problems. She had to. That's the problem with these things, isn't it? You know, we rely on technology, don't we? But anyway, it's all good. Please lock on.
I just want to run you through some of my reflections on yesterday's discussion, and I think they point to some of the key aspects that I raise in my evidence, which I'll take as read. As touched on by Ms. McDonald, I represent a submitted group comprising 13 submitters, and they own land adjoining the application primarily to the north, south and east. I've included a map in my evidence for your reference. First of all, I just want to touch on the activity. The applicant seeks to undertake up to 100 events on the application site for up to 150 people, despite the applicant proposing an extensive list of restrictions by way of conditions of consent. These defining parameters remain. It is on this basis that I've determined what I consider to be a non-fanciful scenario for how the site may be used if consent is granted. With the clarifications provided yesterday by the applicant that activities will not be limited to the warmer, drier months, it is not unreasonable to assume that activities could occur on the site approximately every 3 days throughout the year, as the consent conditions do not preclude this from occurring, or it could be used more intensively over a shorter period of time. And I also note at this point that the consent conditions still enable stacking of the events, which I'll come back to. Further to this, it is not unreasonable to assume that the intervening days could be used for pack in and pack out, as the conditions of consent do not preclude this. And another non-fanciful consideration is the presence of marquees and portaloos on the site for most of the year, because the conditions of consent do not preclude these things. The applicant and the consultants have repeatedly confirmed that the use of the site is for low-key community events with the occasional wedding. However, this is irrelevant because the conditions of consent provide for considerably more than this. While Ms. Walt considers my position to be overstated and lacking in any measure, perspective or balance, the applicant has not offered any concrete conditions of consent that would strike down my summary of the proposed activities. I will discuss the conditions of consent in more detail shortly. Turning now to the activity definition, I acknowledge comments from yesterday that Ms. Walsh and Mr. Giddens, and it would seem to some degree the panel, have largely dismissed the relevance of the activity definition. Respectfully, I disagree. While the activity definition is possibly irrelevant from an effects assessment perspective, it is certainly relevant to the consideration of the objectives and policies. The temporary activities objective and policy framework is very enabling, specifically encouraging temporary events. Conversely, non-residential activities in the Wakatipu Basin are restricted, the Wakatipu Basin zone are restricted. I consider that applying the objectives and policy framework for temporary activities to the assessment of the application is incorrect, and I will take my evidence on my thoughts on the definition as read, rather than going through those now, if that's okay.
Thank you.
Heritage reinvestment. Ms. Walt and Mr. Giddens do not consider that it is appropriate or necessary to impose conditions of consent requiring reinvestment into the upkeep of the heritage buildings. They consider that there is no direct causation for such a requirement. As set out in paragraphs 57 to 61 of my evidence, the application relies heavily on the heritage benefits. I agree with the applicant that there could be considerable heritage benefits and that proceeds from the use of the site could ease the financial burden of maintaining the site. However, the applicant's experts have made no move to confirm these heritage benefits in the conditions of consent, instead relying on the good character of the applicant. With respect, while I acknowledge the substantial efforts and investment of the applicant to date, good character is not grounds for granting consent. The application must stand on its conditions of consent, and any benefits must be included in those conditions of consent. And that's particularly relevant here, I think, if the site is sold. And Ms. Walt does make reference to future owners of the site. So I think we have to assume that the site won't stay in the hands of Mr. and Mrs. Buckham. The application must stand on its conditions of consent. Otherwise, the benefits cannot be relied upon as justification for the granting of consent. As I note in my evidence in chief, reinvestment should be commensurate with building use. To clarify, I'm not suggesting that the funds reinvested will be sufficient to cover the costs of maintenance, but I think it is important that some level of reinvestment is required. Lastly, Ms. Walt seemed to suggest the effects arising from the application should operate on a quid pro quo basis, whereby the heritage benefits simply override the adverse effects. I disagree with this suggestion, particularly when the affected parties are not the beneficiaries of the positive effects. And I touch on that further below shortly. In addition to the comments by Dr. Trevathan, and I refer to him in my evidence as Mr. Trevathan, I'm sorry that I undersold him. I want to touch briefly on the Cargo Brewery case mentioned by Mr. Giddens. Commissioner Baker, as the decision maker, you will understand the facts to a far greater degree than I. But my review of the decision would suggest that the facts of that application are substantially different to the facts of the application before us. The Cargo Brewery site has a recorded history of operating as a bar restaurant, with the emphasis there on recorded. And the activities surrounding the site are predominantly commercial in nature, and appropriate restrictions were put in place to manage the effects of that activity. Furthermore, I find it somewhat ironic that the application is seeking to rely on the approval of the Cargo Brewery activity, a non-complying activity with noise infringements, when Ms. Walt vehemently refuted my arguments that the approval of resource consent for this application could have precedent effects and raise plan integrity issues. Cumulative effects. Mr. Giddens does not agree with my assessment that the cumulative effects on amenity values and the cumulative effects of multiple activities are more than minor. With regards to the cumulative effects of allowing both consented and permitted activities on the site, I consider that the cumulative effects of carrying out 160 non-residential activity days, being 100 event days from this consent if it were granted, and 60 temporary filming activity days to be more than minor. Mr. Giddens has provided no evidence to the contrary. That effectively stamps out the whole year with non-residential activity at the site, particularly noting the new condition that says that there won't be temporary events as well as temporary filming activities on the same days. So there's a lot of very full days with a lot of very busy pack-in, pack-out days. To this end, I note that Mr. Giddens and I have a difference of opinion as to the rule pertaining to temporary filming event. Yesterday, Mr. Giddens, and I think I heard him correctly, summarised the rule as providing for 7 filming days. However, the rule states, and I quote, in any other zone, any temporary filming activity is limited to a total of 30 days in any calendar year, with the maximum duration of film shooting not exceeding a total of 7 days in any calendar year. So as such, I think it's a truer statement that the rule actually provides for 30 temporary filming activity days, of which 7 may be shooting days, which would give this property 60 temporary activity filming days, if you account for the 2 sites that comprise the property. With regards to the effects on amenity values, I have very comprehensively set out in my evidence in chief in paragraph 72 to 88 that I consider the cumulative effects of noise, servicing, and the presence and location of structures on the site would result in more than minor effects on amenity values. I have clearly set out, however, how I have arrived at this position. On the whole, I've found the assessment of effects on amenity values to be both lacking and, we discuss, flawed in the evidence of the applicant's experts. I consider they have taken an overly narrow view of effects on amenity values with a heavy reliance on the temporary nature of the proposal. In his evidence, Mr. Hay discusses and dismisses effects on sleep amenity. And I've got some paragraph references here if you'd like them, as well as the effects on a residential amenity, which is based on the idea that permitted temporary activities on adjoining sites form part of the environment, which I think Commissioner Baker picked up on yesterday. He concludes that the proposed consent conditions provide mitigation for the potential noise effects, demonstrably preserve a satisfactory level of amenity, and result in a proposal that is in keeping with the permitted activities at surrounding sites. Mr. Giddens has limited his assessment of amenity effects to visual amenity and noise amenity. He states that visual amenity effects in relation to the proposed wall are irrelevant on the grounds that policy 26314, which is a heritage policy, only protects views from public places. However, this is not relevant to an amenity assessment. He considers that views of the activity and the temporary structures will be fleeting, intermittent, and temporary. And I just don't think that can be the case when there's 100 event days and potentially 300 activity days associated with that. At paragraph 755, Mr. Giddens states that noise amenity will be maintained due to compliance with district plan requirements. And I submit that compliant noise doesn't represent no noise, and that the audible non-residential noise is inconsistent with the amenity of the rural residential area. I do not think that Mr. Giddens has sufficiently addressed or considered the cumulative effects of the proposal. Indeed, at paragraph 8.2f of his evidence in chief, he dismisses the notion of cumulative effects outright. As already stated, I consider that the cumulative effects on amenity values do arise as a result of the proposal, and the effects are more than minor in their nature. I just want to talk briefly about the management of the site. This has been touched on by both Ms. McDonald and Dr. Trevathan, but I guess the crux of it is that it's evident from the conditions of consent that the applicant has provided that the events manager will not necessarily be the consent holder and will not necessarily be the same person event to event. And I have a number of any sort of condition that is mentioned in the final set that was provided yesterday kind of speaks to that. Given the scale and detail of what is proposed, I consider that the events manager role to be critical to the appropriate management of the site in accordance with any consent conditions. I appreciate the applicant may not want to assume this role, but consider that the delegate must be someone independent of the event company or individual that is hiring the site to uphold the conditions of consent. I consider the conditions of consent remain far too loose in this regard, where there is no clear delegation or nomination of an independent events manager. That's obviously in the event that the consent holder does not wish to assume this role, but that is implied by condition 12G. And certainly based on following the comments made by Dr. Trevathan, I think that an events manager may be the only common thread across all of these diverse activities that could be carried out on the site. And the technical nature and the complexity of the conditions of consent, I consider really do call for a single event manager who's across the issues really. Objectives and policies. Despite suggestions by Ms. Walt that I've cherry-picked objectives and policies to suit my arguments, I note that a full assessment of the relevant objectives and policies is contained in my evidence in chief. In summary, I consider that the proposal is contrary to the relevant strategic directions and the relevant objectives and policies of Chapter 24 and 36. I consider that the proposal could be consistent with the heritage objectives and policies provided suitable conditions of consent are imposed relating to reinvestment for the maintenance of the heritage buildings on the site. I do not consider that the application as it stands passes the gateway test, and accordingly resource consent should be declined. Notwithstanding that, I have some comments on the conditions that were provided yesterday, which won't surprise you. So I guess I'll just start at the top and work my way through. Condition 3 states the regular day-to-day use of the property shall be for rural residential activities. Now, I assume this means that the applicant will relinquish their subdivision consent that they hold for the site, because in the event that that subdivision consent is given effect and the events venue site sold, the predominant use of the site would not be rural residential activities, and therefore the consent holder could not be in accordance with that condition. The condition 4, 100 temporary events is still too many for the site, I submit, on the basis of my evidence that I've prepared, due to the effects of the proposal and how they sit within the objectives and policies framework of the PDP. Jumping down to, I have one comment about 4C, the duration of events. So it says 6 hours, excluding set up and pack down. I guess my comment there is, how is this enforced? I know from my own experience with weddings, it's not uncommon for guests to arrive on site up to an hour before the bride and groom might arrive or the ceremony might start, for mingling and having a glass of bubbles. So is that when the event starts, or does the event start when, you know, the bride's song starts and she starts walking in? So that's my comment around that. Conditions 5 and 6. I guess this is where I really want to talk about this idea of stacking of events, and I guess the issue picked up by Dr. Trevathan, which is there's no respite. So the way the conditions are structured, they would still enable 2 events every weekend for a fairly good portion of the year, and that provides no respite for the neighbours. So I have an issue about that. Going to condition 8, as Dr. Trevathan has also touched on, condition 8 doesn't prevent 2 events occurring in a day. So that has obvious noise impacts on the way that the noise has been assessed, but also just in terms of the level of activity that would occur on those the 12 days when a nighttime event could take place. They could potentially be 12 hours of activity, or longer if there's any sort of, if it's an event not rolled over from the morning. If it's a totally new event, there would be potentially 150 cars leaving, and then 60 or 70 cars leaving, 60 or 70 cars coming. So it could be a whole new group of people coming and going from the site. I think condition 9 really just talks to this idea of spreading more activity, non-residential activity, over the site over a longer period of the year. There was a condition of consent in an earlier iteration that I saw that restricted the use of outdoor area 2. And that hasn't made it into this final version, but that talked about limiting the number of people outside. Maybe there's some implication in what the noise and operational management plan will enforce, but there was a clear condition of consent which is no longer there. I guess the question is why. So there's no restrictions on staff use of the site. So I guess the example I point to is if you've got 2 events back to back, one activity maybe have to be completely packed down so that some people can arrive early on the site next day to start packing, bedding in for the next site. So does, the way the conditions of consent are constructed, does that mean that, someone has arrived? Does that mean that staff could work on this site until 4 a.m. in the morning, with clanging plates and trestle tables going up and down and chairs being stacked? And, it's very unclear how staff can move about the site and use it. I've already talked about a single events manager, or the need for a single events manager. I've talked about that. Dr. Trevathan talked, he touched on the reality of the doors remaining closed, particularly on a hot summer's night in an unventilated shed, where there's dancing and partying going on. Condition 14 talks about verified noise complaints. I think this sets an unreasonable bar on, I mean, who is to verify the noise complaints? Every complaint should be taken seriously and followed up on and addressed accordingly. Just a comment, there was something raised with Ms. McDonald about condition 16 and people to be contacted or about the events that are going to occur. That's not a complete list of the people, the submitted group that I'm representing. I just wanted to clarify that. I guess I just have a query about the enforceability of condition 17C. If it's 3 days before the event, is the event organizer really going to go to the council and get all of their equipment verified and confirmed for the use at the site? If it's not the standard, if they're not going to use the on-site calibrated system. Dr. Trevathan's already provided comments on condition 20, but there was suggestion yesterday that that the monitoring wouldn't be carried out on maximum event or maxed out events. And I think that condition needs a lot of refining, but monitoring of the maximum events does need to occur because it needs to account for what the consent provides for, the maximum total that the consent provides for. I think all events need to be, I can think those neighbours listed or whatever neighbours listed is the final list is landed on. I think they need to be notified of all events because I don't think that it is only the nighttime events that are problematic. I think it's the accumulation of the 100 events that's problematic. There's no restriction on marquee use, so that points to my comments about landscape and character effects. I picked up on the note yesterday, I think it was you, Commissioner Baker, but the no stopping at all timelines on Speargrass Flat Road. In the absence of those, how is the consent holder really going to enforce a prohibition on parking on Speargrass Flat Road? In terms of condition 37, I would support the construction of the wall only in schist, as this is what's supported by Mr. Knott and Mr. Brown. And to clarify, it's also what's considered acceptable by the owner if they do have the wall forced upon them. So any timber cladding would be unacceptable. And I think in the review condition, the 42C, monitoring of the exercise of the consent has revealed that there is or is likely to be, and I think instead of significant, it should be more than minor effects, on the basis that the argument here really at play is primarily noise, and the applicant has confirmed that they are minor or less. So I think any more than minor effects would need to be revisited. And those are my comments based on the musings of yesterday, and I'm more than happy to take any questions.
Thank you very much, Ms. Tate. Commissioner, do you have any questions of Ms. Tate?
Yes, I do. Ms. Tate, I'm interested in your comments on condition 3, which revolve mainly around concerns relating to the site post boundary adjustment if that's carried out. But that condition strikes me as very unenforceable in any event, as was submitted by Ms. McDonald. There's no requirement that there only be one day-to-day use.
Well, yeah, I guess coming back to my my take on the activity and what the activity is defined as, I think that I agree with Ms. McDonald, and I think that the events venue would comprise, in addition to the rural residential activity, the day-to-day use of the site. I'm not really sure why it's made its way into the conditions, other than the applicant might be looking for a way to affirm their position on the temporary events definition. But in any case, it's there. And I think in order for it to be, in order for the consent holder to comply with it, then the two sites would need to be held together as a single property. And I think the certainty would come from the applicant relinquishing the subdivision consent.
Well, I guess that was my question. You've just, in the last bit, suddenly, my question was, what difference does it make whether the boundary adjustment's carried out or not?
Well, I guess it would enable the site to be sold independently of the applicant's dwelling. And then it wouldn't, there would be the house sitting on one site and the events venue sitting on another site, and operated independently of the applicant. And I don't see how.
But Ms. Tate, we already have half of it sitting on another site which could be sold.
Yes, correct.
The boundary adjustment may make it a slightly more attractive prospect, but we already have that situation.
Correct. I guess I see no purpose for the condition.
Okay. You commented about staff banging around on site in the middle of the night.
Mm-hmm.
Now, I'm just reading through A to N of Mr. Giddens' noise and operations management plan proposal, and I'm not sure it's immediately in there, but I guess it could be included in there, a condition about the hours that staff can be on site.
That's what I would have expected, and I did herald that in my evidence in chief, but it hasn't made its way into the conditions.
Okay. Now, you mentioned somewhere about verified complaints, and I couldn't actually see that in the conditions. I'm probably not reading properly.
Condition 14, any mitigation measures required to address verified noise complaints.
Yep, I see. Okay, thank you.
I think that puts an unreasonable expectation on the complainant.
Yeah, I understood your point. I just couldn't follow where you were. In terms of condition 17C, your own noise expert, Mr. Tarathan, was comfortable with that condition. So, but you've said it's too unrealistic. It's obviously an alternative option available to people. It's not the standard. I don't think it's problematic from that point of view, is it?
I guess my concern about the conditions of consent as a whole is how enforceable is that? Like, who's going to know that there's that the in-house system isn't being used, and whether or not if it's the ability to monitor these things that I have the greatest concern with.
I don't see the problem monitoring this. Monitoring officer turns up and looks at the thing.
If they're called to site.
Well, in all resource consents, we are reliant on the consent holder generally working in accordance with conditions. The council doesn't look at every single thing, so I think that's okay. I understand your concern. Okay, I don't think that I actually have any further questions for you, Ms. Tate. Thank you.
No, either do I. understand your evidence. I understand things, what you put forward to us today. So thank you very much.
Thank you very much.
Ms. McDonald, is there anything else, or is there any of your submitters who'd like to say anything?
I don't understand that any of the submitters wish to say anything. I just would comment on one of those last questions that Commissioner Baker put to Ms. Tate about what difference it would make if the boundary adjustment was completed, because there is already a situation where there are part of an events venue on one title and part on another. I just want to say that might be all very well, but don't forget that's in a scenario where we're operating under the permitted activity rules in the plan. And I think the evidence for the applicant is very clear that if there is going to be an increase to 100 events as sought, then that requires quite a different and much more hands-on management regime than applies at present. But that's pretty much the submitter's case. Thank you, commissioners.
Thank you.
Yes, thank you for your time.
Thank you very much, Ms. McDonald. Very helpful.
Thank you.
Ms. McConnell, do you want a 5-minute break so you can get the batting? I apologise for using the sporting analogies. To get the order in the right order, or are you happy to just box on?
Thank you, Commissioner. I am ready to box on. I believe, have a look at the above my screen, Mr. Hewlin, Mr. Knott, and Mr. Stiles are all present. If either of you three are not, please speak up now. Otherwise, I'm happy to introduce myself and get the ball rolling.
Okay. Is there? I saw Mr. Knott was online. You there, Mr. Knott?
Yes, I'm here. Can you hear me okay?
Yes, all good.
Excellent, thank you.
And I can see the other two, I think. All right. On that basis, we'll proceed. So how do you want to proceed, Ms. McConnell? I mean, obviously you've heard all the evidence. You've sat through the last day and a half, or almost coming up to a day and a half. How would you like to proceed? Would you like to give us a synopsis of what you've heard and any comments you'd like to make to us, and then would you like us to go through and talk to the 3 experts you've got with you, or would you like us to start with them and then come back to yourself?
Thanks, Commissioner Beattie. A lot of my conclusions are informed by my 3 experts, being Mr. Hewlin, Mr. Stiles, and Mr. Knott. So I think it possibly would be most appropriate if we hear from Mr. Hewlin first on traffic, and then Mr. Stiles on acoustic effects, and then Mr. Knott on heritage effects. And then I am more than happy to provide a statement of what I've heard over the last day and a half, and then answer any questions from the commissioners.
Okay. We'll proceed on that basis. So we'll go to begin with traffic, please. Is there anything you'd like to update us? Obviously, we've got your memos and everything, they're all being read and such like. We may have some questions, but is there anything you'd like to update us in light of what we've had over the last day and a half?
It seems like the only remaining point of difference between myself and the applicant's expert is in relation to the access at the eastern end and the need or not for widening that to provide for a larger vehicle. And I had recommended a condition that that vehicle size was based on the 11.5 metre vehicle, and the applicant had proposed that has shown and demonstrated that the 8 metres vehicle can access that eastern one, but anything larger than that's going to require some multiple manoeuvres. And my view is that it's not a significant amount of widening to accommodate the larger vehicle. I think Mr. Bartlett referred to approximately a metre of overhang of the vehicle. And by widening it, you eliminate any risks. By relying on the temporary traffic management, there are some associated risks. In saying that, I don't think that they're particularly significant, and I don't expect the frequency of them to be significant either, based on what I've heard in the last couple of days. So it's not a die in the ditch thing for me, if you want to put it like that. But I'm just pointing out that by engineering the risk out, you're removing it. Otherwise, you're relying on an operational process. And so that's my point in terms of the different size vehicles and what should be catered for at the access and what can be catered for with the use of traffic management.
Thank you very much. So just picking up that, so just picking up your last point, is it you sort of almost implying it's a nice to have, not a need to have, in terms from a traffic engineering point of view? Is that what, if I understand you correctly?
No, it's my view that that would be the better outcome.
Would be a better outcome. And do we need it? Because I mean, we had a bit of discussion about length of vehicles and the types of vehicles that would come onto the site, as you know, like yesterday. So from a traffic management safety point of view, would it be, I'm just trying to get the head around, if we were to go down this road, in your view, is it something we should seriously think about if we were to impose a condition to require that, or is it, as you say, a nice to have? I'm just trying to get my head around about where you're landing on that, really.
Well, it's definitely my recommendation and my preference to see the crossing widened to accommodate the larger vehicle.
Yeah. Thank you. Yes,
Mr. Hewland, can I ask a follow-up question on that?
Lost my pen.
The alternative is obviously a traffic management plan. And I'm very aware of putting extra burden on the council in terms of enforcement and monitoring. What role does the council have in a traffic management plan? Is that a significant amount of administration extra?
Not in this particular case. And I talked to the officer who permits the temporary traffic management plans in regard to this application. And in this case, where they can actually be granted a standing or ongoing traffic management plan for that purpose. And as long as the parameters were the same as what they had applied for in relation to the impact on the road, then that can be one that they don't have to go and get each time for every single event, as long as they're implementing that same traffic management plan for the same purposes and in the same way. My concern, though, is that different event organisers are going to be using the facility, and then can we expect to see the consistent results from that as a result of that? You know, it's something, I guess, that it's not always in the hands of the consent holder. And I think that the proposed conditions to advise the event management of various things and requiring that by condition is helpful and should be included. It's not clear to me whether those event organisers would always have the necessary skills to implement the traffic management plan in accordance with the requirements.
So is that an issue that could be resolved similar to Ms. Tate's concerns, really, by having one person in that role of event manager, rather than it being contracted out or handed out to various wedding or planners or whoever it is? And think of it being Mrs. Buckham, but it could be a delegate of Mrs. Buckham's, but a fixed person who always is there and understands the site and understands all the intricacies, and in this case understands the intricacies of the traffic management plan.
Yes, I agree that it would definitely reduce the risks.
Thank you, Mr. Hewland.
Yeah, thank you very much. That's very helpful. Nothing more. Do you anything more from you, Commissioner?
Thank you.
Okay, thank you. Thank you very much, Mr. Hewland.
Thank you.
Is it Mr. Stiles for noise?
Good morning.
Good morning.
Good morning.
I have a short statement that I've prepared just over the last few hours, really. I'm not sure if it's made it to you.
I'll just check my email. I don't
have it.
No, I
Okay.
don't have it yet. But I was going to say, just as I've said, we'll come to the end soon. As I said to Ms. McDonald, I would like these be very beneficial for my colleague and myself if we do have these comments in writing. So I'll set a time frame for it all to happen at the end. So if you could, so we can pick it up then, Mr. Stiles.
Okay, well, I could email it through to the administrator now.
Yeah, if you could send it to Ms. Anderson now, that'd be lovely.
Yep, okay, I'll do that right now.
Okay, might as well just get going. We'll catch it up when we catch it up. We'll
Okay.
have it in writing.
I've sent those through.
Thank you.
Okay, now I need to open them. Bear with me, sorry. So, just kicking off, I think it's good to introduce myself and have you understand why I'm here and not Mr. Exeter. He's simply not available to attend this hearing due to personal commitments, so I've stepped in. But I have worked with Mr. Exeter in the preparation of his advice to the council, and I'm familiar with it, obviously, and I adopt that advice as my own. I visited the area on Friday, the 16th of September, so that was just last week. I didn't go onto the site, but I did spend some time observing the general area from several locations at the roadside. My experience from involvement in other projects along Speargrass Flat Road is that the passing traffic becomes very intermittent into the evening and nighttime period, and the ambient noise levels can be very low at times. I've had several recent discussions with Ms. McConnell to confirm our findings. That's my findings and Mr. Exeter's and assessment methods. The assessment undertaken by Mr. Exeter and myself is based on what the proposed conditions would authorise. And I've got some comments to provide to you following the evidence and questioning that I've observed during the hearing. I've been present for almost all of it. I had to miss a couple of short sections yesterday, but otherwise I've been listening in. Just a preliminary point on the World Health Organization guidelines. The advice from Mr. Exeter does not mention those guidelines. Mr. Hay appears to have inferred that Mr. Exeter was drawing from them in his advice to the council. That's not correct. The opinions provided in our advice to the council about annoyance and related effects are based primarily on the experience that we have had in measuring, assessing and helping manage a large number of event and function centres in rural areas across the country. The ambient noise environment and district plan provisions have also been a factor in the assessment. I'm just going to refer to them as the WHO guidelines, if that's okay, because it's less syllables. The WHO guidelines have been developed to provide recommended targets for reducing noise levels in urban environments that are heavily impacted primarily by noise from major transport infrastructure. The WHO guidelines do not provide any guidance on amenity, especially in otherwise relatively quiet rural areas. I was heavily involved in the Cable Bay Wines Environment Court case that has taken place in Auckland over the last few years. I should add that in the written comments, there are footnotes with web links to all of the material I'm talking about. In that case, the court applied noise limits 8 decibels lower than the permitted standards. So the noise limits and the conditions were 42 dB LAEQ during the day and 32 dB LAEQ at night to ensure that the noise effects will be consistent with the outcomes sought by the objectives and policies for that zone. The court explored the relevance of the WHO guidelines in that case and ultimately discarded them when it was obvious they provided no guidance on rural amenity. In my opinion, the noise level reduction targets in the WHO guidelines have no relevance to the objectives and policies in this zone and cannot be related or translated into an assessment of whether the effects on amenity in any rural zone can be less than minor or otherwise. In my experience, the determination of whether effects are minor or more than or less than minor or whatever it might be in the resource management context is a determination for a planner to make based on a wide range of considerations. Mr. Exeter and I have described the noise effects using common dictionary definitions and clear descriptions to allow Ms. McConnell to make her recommendations. The annoyance thresholds used in the WHO guidelines are, in my opinion, entirely different to the way an annoyance effect might occur in a rural zone, where the occupants can derive expectations around amenity from carefully crafted plan provisions and the noise limits that control activities. Furthermore, even if the WHO guidelines were relevant, they make recommendations for all noise sources. So in other words, they provide targets for reducing noise, all noise sources, down to a certain level. In this case, it would mean that the total cumulative level of anthropogenic noise in the area would need to be assessed and controlled. This would include road traffic noise and the noise arising from the proposal. Mr. Hay has not evaluated the cumulative level in his assessment. In my written statement, I've provided some excerpts from the 1999 and 2018 WHO guidelines that demonstrate why they are irrelevant. And again, I've got internet links there to those documents. And so for those reasons, I consider that the WHO guidelines are irrelevant and should be set aside. Moving on to conditions. In my view, the proposed conditions and management arrangements are complex. I agree with the concerns of Dr. Trevathan around the complexities. I agree that relying on closed doors for the barn is problematic unless those spaces are air conditioned or mechanically cooled to provide fresh air and thermal comfort. Otherwise, there is simply a temptation to open the doors and leave them open for those reasons. Having the toilet facilities in a separate building is also problematic in my view, and I think that that would lead to the doors being opened on a regular basis and therefore letting the noise out. I consider that the noise management plan would need to be detailed and quite complex, and I think it should have been provided or updated and provided as the proposal has been successively modified. I consider that compliance with the proposed noise limits will require a high degree of management and reliance on staff to manage activities, noise levels, and potentially to manage the behaviour of guests. I consider that the proposed noise limit condition requires interpretation of subjective terms that will be difficult to accurately implement. In my view, there is ambiguity around the sound system and potential use of a temporary system. I consider that the conditions should only permit a permanently installed and calibrated system. I think that any provision to allow a temporary system indoors or outdoors will create considerable uncertainty for compliance and an added level of complexity for the conditions to address. I also wanted to comment about the reliance on noise monitoring. I felt as though some of the comments earlier this morning made it seem like it would be quite simple just to put a noise limit condition on and rely on monitoring to deal with monitoring compliance. In my experience, noise measurements are often very difficult to arrange. They're reliant on reasonable weather conditions, so no rain and relatively low wind, especially in an area such as this with a lot of trees. The wind in the trees will affect the measurements significantly. To do the measurements properly, you really need to be at the assessment position, which is on a neighbouring property, so you need access to that. And you have to have a high degree of confidence that the event you've chosen to monitor is representative of the more intense or noisy events that the consent would authorise. Noise measurements are also reliant on other noise sources being relatively low so that they don't affect the measurements of the sound of interest. This includes natural sounds such as birdsong, and it would also include passing traffic and any other noise that a neighbour might be making. In my view, the conditions should rely less on monitoring of noise and more on determining the controls required to achieve compliance now. I consider the conditions require some considerable improvement and that the noise management plan should be provided or updated and provided to reflect the current proposal. I'm almost done. Noise effects. I've assessed the number of proposals against the Queenstown District Plan rules, quite a number of proposals, in fact. I'm very familiar with the 8 p.m. onset time for the nighttime noise limits. In my opinion, the 8 p.m. onset time has been designed to deliver a high level of amenity in the evening period, allowing for outdoor socialising, quiet time, and a higher level of evening amenity in the period before sleep protection is generally necessary from 10 p.m. In my opinion, based on my experience of drafting plan standards for temporary events all over the place, assisting councils to process resource consents, monitoring of consents and temporary activities under the permitted standards in various locations, and advising applicants seeking consent for temporary events. In my view, 100 events per year is a frequency that is considerably greater than temporary, occasional, or infrequent. I consider the proposed frequency of events as more consistent with a function venue operating roughly every weekend of the year. And just to sum up, I consider that the descriptions of the effects provided by Mr. Exeter in his advice to the council remain valid and appropriate. And I'm happy to answer any questions.
Thank you very much, Mr. Stiles. Commissioner?
Thank you, Mr. Stiles. Thank you for that quite detailed explanation of the WHO guidelines. That was very helpful for us. I just wanted to have a look at the conditions with you, really, because obviously you have some concerns with the conditions.
Sorry, could I just interrupt? Sorry, I don't know that I have the very latest set of proposed conditions. I should have been prepared for that. I apologise.
So these were the set we're talking of is the set that Ms. Volk gave us, or was submitted when we arrived on Monday. Ms. McConnell, could you just email Mr. Stiles that just to be sure that we're all on the same song sheet?
I want to make sure I'm using the same ones, absolutely.
Yeah, no, totally, that's totally appropriate. We don't want to be talking cross purposes here. Or if you haven't got that, Mary Trish, could you send it to?
Yes, Ms. Anderson is forwarding them right now to Mr. Stiles.
Thank you.
Commissioners, Ms. Walt here. I'd just like to make a couple of points, if I may, about Mr. Stiles's summary that he has just presented. And I'll address some of this further in closing. He has opened by saying he has adopted Mr. Exeter's report, but then appears to have diverged quite significantly from it in his summary in a way that, and we haven't had an opportunity to respond to that. So I think there's a process issue there. He's also been at pains to discuss the conditions and the adequacy of those, and has now just said he hasn't actually looked at the latest conditions, which have been substantially amended from those that were or that are contained in Ms. McConnell's report. And in fact, the focus of those amendments has been to address noise matters. So I'm not sure how much you can rely on what Mr. Stiles has just said about those conditions when he is in fact has not assessed the latest ones, which go to the heart of the concerns he's just raised. So two issues there, a process one, and then I think that probably Mr. Hay needs to be afforded the opportunity to respond to Mr. Stiles' evidence that he's just given once we've received the written copy of that. But also, I think, from a weight perspective, you need to be quite cautious as to the weight you just give his comments, given they are not based on the current proposal.
I think we're going to have there's a few, Ms. Holt, you raised a lot issue, and there's a few other issues that we've been talking about in the break that we'll come back towards the end, but totally take the point about process. Obviously, the right of reply can come back and deal with that. But potentially we might, and I'll signal now, potentially we might be asking for some more information before we can even go, before we'll ask for your Rose reply. And I'll sort of signal what we're thinking about. We're thinking about, we'd like to see the details of the wall. We haven't seen this wall, apart from a description of it. We'd actually like to see some visuals of what that potentially looks like. There's also potentially the issue of the marquees. I think that's a very valid issue as well. And what I was proposing to, I might as well go over it now, what I was proposing to do was signal that after we've heard from the council witnesses is to set a time frame for the summaries that Ms. McDonald's witnesses had given us, and potentially the council witnesses had given us. Then also asked a time frame for you, how long it would take you to provide us with that level of information. And then we would make a determination, and we can walk about the time in the month when we get towards the end, but just signaling what we're thinking. And then think about whether we need to call further evidence, or if we're sufficient, we've got enough. If we do have enough, or we need to set down another hearing time, we will. If not, we'll send out minutes to that effect and then give you your opportunity to write your right of reply. That's what we're sort of thinking of at the moment. We'll probably have a break after we've heard from the council officers because unfortunately, we're not in the same room, have a bit of a chat, Commissioner Baker and I, and confirm that. But that's what we're signaling at the moment.
Yes, well, that generally sounds appropriate, and subject to resolving timeframes for all of that. Just with respect to the summaries, I would expect that those ought to be provided today, because I wouldn't want to. Obviously, the witnesses had been reading off summaries, and I wouldn't want to see new evidence come in through those summaries that hasn't been presented today. And that the commissioners haven't had an opportunity to put questions to the experts on.
Very cognizant of that point. That's why I'm sort of signaling that potentially we don't know where we'll land, but we're just giving ourselves that option open to ourselves. But yeah, I totally take the point, or we take the point. So shall we box on, and as I say, we'll get to the end and we'll set down these time frames, and we'll, as I say, Ms. Baker and I'll have a bit of a chat before we do that, just to make sure we're on the same strong suit, given we're not in the same room. But thank you.
Yes, thank you.
Back to you, Mr. Stiles. Have
Sure.
you got those conditions now?
I do, and perhaps I might have caused some confusion there by using the wrong words. I wanted to make sure that I was using the right conditions, and the ones that I've just been sent by Ms. Anderson are the ones that I've been referring to. So I don't think there's an issue there. And just in terms of departing from the advice that Mr. Exeter provided, I don't think I've done that either. I've provided comment on the WHO guidelines, which is a new issue that's popped up. Complexity on the conditions, which I've just clarified as being, I've used the right set. And then confirm that I remain of the view that Mr. Exeter's assessment of the effects is appropriate. So I don't see that there's any diversion there at all. Anyway.
So we're with you, Commissioner Baker.
Yes. Yeah, so Mr. Stiles, I just wanted to quickly run through the conditions with you and just to address some points where you have raised concerns. And you have raised concerns similarly to Ms. Tate with the enforceability and the complexity of condition 17. Now, I said to Ms. Tate, that's my understanding is that option C is the outlier. That's not the preferred option for anybody, because it's quite a lot of palaver, for lack of a better word, but it's there to allow that option if necessary. Is that really of great concern?
Bear with me, sorry. Got quite a few windows open here. I think the proposition itself of allowing a temporary system is of no real concern. It does add complexity. I think, though, the way it would work on the day is quite difficult to administer in my experience. So it doesn't come down just to the level. It comes down to the way it's used. Its orientation to a relatively precise degree in terms of orienting the speakers and things like that. there's also quite a few variables involved in setting up these PA systems, and it's not really as simple as saying we can set up a system and orient the speakers in this location and it will comply. In my opinion, that suitably qualified person that is talked about there would very likely have to be on site that day to set it up and set what's called the gain levels on the speakers to their maximum. That's generally an undesirable state of operation, and to set some kind of limit on the volume settings, which are numerous in a commercial PA system, to make sure it will work. And any of those settings could be changed later in the evening by someone who may not be aware of the controls, or may be. And in my experience, one of the issues that these venues face is a drive to meet the desires of the client. So they may have hired the venue and paid money for an additional system to be used in a new location, outdoors perhaps. And very often there's a tension between achieving an adequate level of speech or music and complying with a noise limit. And when the system is set up permanently inside a building, for example, that system can be set up, calibrated, and essentially the door closed and locked so that no one can play with the controls. But in my experience with these temporary systems, it's quite common for there to be, as I say, tension and a desire to increase those. So I think it's complicated. I'm not saying it's unachievable, I'm saying it's complicated.
Excuse me, I'm sorry to interrupt, and I know this is quite out of turn, but I just, Mr. Stiles is talking about a temporary system. 17A provides for and requires.
Sorry.
No,
sorry, Ms. Walt. I think
no.
that we want to hear from Mr. Stiles.
Okay.
Yes.
I just am concerned that he's not.
We would like to hear from Mr. Stiles. Thank you.
So I'm looking specifically at condition 17C, which talks about instrument equipment may only be used independently of the in-house system if it can be demonstrated by a suitably qualified person that it's useful, not caused. So that's the condition I'm looking at specifically.
That's
so
the condition I'm asking you about, yeah.
That to me indicates that there is an avenue for the consent holder to set up a PA system in one of the outdoor areas, for example, so that speech for a wedding ceremony could be amplified, for example.
So are you saying to us that setting up that equipment would involve testing, which in itself might have noise effects?
Yes.
Okay. Thank you.
They could be relatively brief noise effects. It might only take a few minutes to set that system up. And typically you would play, if it was going to be used for music, you would play a music with a relatively high average level for a period of several minutes to get a consistent measurement at your assessment point, and then you can adjust it up or down from there as required. So it's typically an iterative process to adjust those levels that wouldn't take more than, depending on the system, maybe 5 or 10 minutes.
Okay. And then condition 20, which is about the monitoring. So my understanding from you is really that you're saying actually that condition is pointless, get rid of it.
No, it's not that it's pointless. I just felt this morning that Dr. Trevathan in particular was and I might have this wrong, and maybe your interpretation of his comments is different, but I got the impression that he was saying maybe it's okay simply to rely on monitoring to mop up any, and these are my words, mop up any uncertainties that might exist elsewhere in the conditions. So if there's flexibility to do this or that, then you can live with that because you can go and monitor the noise and see if it all works in practice. What I'm saying is that monitoring process can be difficult. There's a lot of ducks to line up, and it's not just as easy as turning up there and doing a measurement. There's going to be potentially a whole lot of variables to control.
So, but you don't have concerns with the modelling that's been undertaken, so you generally agree that the noise levels that are predicted are probably within the realms of reality.
Yes. There will always be variation because these sources are variable, and there might be most likely some occasions where it's lower than the predictions.
Yep.
There may be some very short periods where it's a little bit higher, and that's where that management control comes in.
Okay. Thank you. I don't have any further questions. Thank
Right.
you.
Thank you, either do I. Mr. Knott.
Good morning, Commissioners. I
I
too
think
have.
it's just is, Miss Morning. I think it's
Yes, it is. I
still
checked
right.
before I said it to make sure. Yeah, it is just morning. Yes, good morning, Commissioners. I too have been scribbling this morning and put some notes together, which I'm more than happy to
Yes.
provide to you after this. And I wanted to start off, really, if that's okay, just running through some of the points that have been made over the past day and a bit, and made in the applicant's evidence, and then also provide some comments on the conditions from my perspective, if that's okay. I first wanted to say that I think Mr. Miller in his evidence did show a very clear understanding of my concerns regarding the proposal, and where there were elements of support for myself with the proposal. But I think that both Miss Walt in her opening and Mr. Giddens have not understood my concerns. And I think it's important that I confirm at this stage that I fully accept there are some potential positive effects of the proposed application, and we've heard about those in terms of potential reinvestment into the maintenance of the buildings. But I wanted to confirm really that nowhere have I suggested, as Mr. Giddens suggests in his evidence, that the buildings should remain as an unused shrine to the past. Clearly, I recognise there needs to be a future for these buildings, for them to continue and be maintained. And Ms. Walt suggests in her paragraph 100 of her opening, her full opening rather than the summary, that I'm confused or misunderstand the application, and in paragraph 138 that my assessment is flawed. What I wanted to sort of clarify was at the time of the preparation of my report, the application was very open-ended. There was no draft conditions, and the first draft conditions were prepared and dated the same date as my memo. So I think really, given the very open-ended nature of the application, I effectively reverted to my first training as a planner and have merely stepped back and considered the worst case scenario that's possible under the application, rather than any description that may be given of potential outcomes, because clearly the consent, when it's granted, is the consent that's granted, and people are obviously able to maximise what that allows. So given that, I raised a number of issues that I believe require clarification, and those are clearly set out in my memo, but they relate to the maximum number of vehicles on the site, locations available for car parking, and location of facilities such as marquees, portaloos, the potable water supplies, etc., which all need to come onto the site to support these events. And I note that yourselves as commissioners raised similar questions yesterday of witnesses regarding those very factors. I'd also like just to respond to a point made by Ms. Walt in paragraph 106, where she notes that I don't carry a full assessment of the relevant provisions. I've focused in
Sorry,
my memo.
Mr. Knott, can I just take you back for a moment? You said there are all these questions. Have they now been answered for you?
I was going to address that in a moment, where I'll go through the conditions, because I think the conditions have sought to address those questions. And if it's okay, can I just cover those off in a second? I've got a couple of more things I wanted to mention,
Sure.
And then move on to those.
Sure.
So if I could do that, thank you. In terms of my assessment, I've focused on those provisions which appear most relevant to the proposal, because a number of the objectives and policies are either very general in terms of what they consider, or very specific and not relevant. So I really have just sought to address those which are most relevant. But I do believe, in any event, it's most appropriate for Ms. McConnell to carry out the full assessment under 104D, considering all objectives and policies that are relevant across the plan, rather than me doing so. And it seemed a bit of a criticism of me that I wasn't doing a 104D assessment. And also, I'm surprised that in that comment, Ms. Walt suggests that I should have taken into account the positive impacts of the proposal on historic heritage, where clearly it's my understanding that under 104D assessment, you can't take into account the positive effects. In terms of the effects assessment under 104D, we can only look at other effects. So in relation to the comments that she made in relation to policies 26.3.1.2, and I've got these written in the notes that I'll pass through to you. 26.3.1.3, I clearly recognise that the provision of interpretive material will assist with increasing the knowledge and understanding of the heritage values of the site. But in relation to the maintenance and repair of the buildings, I note that it was confirmed yesterday by the applicant that they don't in any way look to specifically tie the consent to the maintenance and repair of the buildings. So clearly, in considering those two policies and the elements of those which relate to the maintenance of historic heritage, there isn't a direct link between the proposal and those and the future maintenance of the buildings. So now moving on to your question, Commissioner, regarding whether the concerns I've raised have been addressed. I've gone through the proposed conditions to see whether they have been. And whilst the proposed conditions attempt to provide further clarity regarding the proposals, and in relation to many of the issues I've raised, I have found that they in general lack specificity, and I think some of them can be open to interpretation. First off, so I've just got some bullet points here. I note that the conditions say they're to be read in conjunction with the plan that's included in Mr. Giddens' evidence, which is the two plans in his evidence, which is in his evidence in chief, which label the buildings and label the areas. Now, I don't know whether you have that before you.
Yes, we do.
Yeah, good. Okay, so many of the conditions make reference to the farm buildings. I don't think the farm buildings is a term that's used on either of those plans. So it would make more sense to me to ensure the conditions used naming terminology that was used on the plan. Otherwise, there could well be confusion over what they relate to. And I think we all have a good understanding of that stat here, but give it another 5 years with entirely different people involved with the enforcement of these conditions, there could be confusion over that. And just another point which isn't directly relevant to my case as such, but condition 25, I just wonder whether the table included in that could cause confusion, because it makes reference to events which are larger in numbers than the numbers of attendees that have been spoken about in this instance, and also talks about duration of events, if I understand the table correctly, which are longer than is being applied for. So I presume that table in condition 25 is the standard table that's just been lifted from elsewhere, but I do wonder whether that may cause some confusion. But it is good from my perspective to see that that does provide clarity regarding the number of portaloos that are toilet facilities, portaloos that are required for an event, and I'm glad to see that the plans clarify where those could go. In relation to condition 27, which is the condition regarding marquees, again, with the plan that's now been provided in Mr. Giddens' evidence, I'm pleased that that clarifies the potential locations for marquees, both of which I think are acceptable locations. But I think the difficulty is I don't believe that it provides clarity regarding the number of marquees or the size of those, and I think both of those are potential issues. And unless there's something I'm missing and don't know there's a standard size for a marquee, but I believe a marquee could be sort of any size, and under that condition there could be any number. So that doesn't it goes some way to providing overcoming my concern regarding marquees, but not fully. In terms of 28, which is under traffic management, which talks about car parking, it talks about the number of car parks available for specified numbers of guests, but it doesn't clarify whether those vehicle parks are the only vehicle parks available or whether there's other vehicle parks available for staff. I mean, I presume that that should be interpreted to meaning parking spaces overall, but I think we need clarification regarding that.
Mr. Bartlett clarified that he included staff in 60 vehicles.
So, but in terms of the 20, 35 and 50 spaces made available under 28, I would think that the condition would require clarification to confirm that that's parks of staff and guests.
I mean, is your concern here about the location of these and the potential impact on the heritage?
That's right. So, I mean, if potentially we have an event of, let's say 150 guests where we have 50 vehicle parks, and I know it's been mentioned there could be 10 staff, but let's say there's 20 staff, you know, I just don't think the condition as it's written provides the clarity that's required. I'm sort of about events for guests.
I'm sort of just picking up Commissioner Baker's issue about addressing the issues, and I suppose we're trying to link it back to your area of expertise in terms of heritage. And are you saying, is that your concern? You want to know where these car parking spaces are because of the potential impact on the heritage building?
Yes, and the volume of car parking in any instance, because those two together have an impact upon the setting of the heritage building. So yes, this is very much related to my area of expertise in terms of impact upon heritage. Not it's under traffic management, but it's actually, my concern is a historic heritage issue.
Okay, sure, okay.
And same with the marquees, is about the relationship of the marquees and their potential impact upon the setting of the historic heritage building. So the larger the number of marquees and the greater number, larger number and greater size of the marquees, they have more potential to impact upon the setting of the historic heritage buildings. And then condition 37, this is the condition regarding the proposed wall. And I wanted to provide some comment on that. I think there was probably some confusion on my part regarding the proposed wall, and that's led to confusion on other people's parts regarding the location of the additional planting that I'm suggesting. I had assumed when I was on site that the planting along the application site, along the boundary with 37, sorry, is it?
67.
67, so I've miswritten it here. 67 Speargrass Flat Road. I'd assume the planting on that boundary would remain and the wall would be built on the inside, the site side of that. So you would end up along that boundary with the existing post and rail fence, the planting, and then a wall on the inside of that. And so my recommendation was that gaps within that existing planting along that boundary be filled, not that gaps along the front of 67 Speargrass Flat Road be filled, because clearly they're beyond the application site and beyond the control of the applicant. So my assumption was that that planting would remain, which would then soften the view, remain and be boosted, which would soften the view of the wall from the direction of 67 and also in the glimpses that are available across 67 from Speargrass Flat Road as you drive along that road looking towards and approaching the site. So that was the first point I wanted to make regarding that. Shall I move on to the second point, or did you want to, do you need any further clarity on that specific issue?
Commissioner, shall we move on and just wrap this up?
Yes, please move on.
Yeah, okay. So the other point, and this is the last point in my report, is my notes. You will see that I've recommended in my memo that I believe that wall should be constructed of stacked schist with vertical coping on it, rather than the other option that's also provided within the condition 37, is that it be constructed of weathered timber or weathered timber with a mixture of stacked schist. My concern is basically the end appearance of that, and I wonder whether, from your comments that have been made, whether you have seen the illustrations that have been provided as part of the heritage assessment provided by Mr. Miller in his original heritage assessment. The original heritage assessment provided by Mr. Miller in Appendix B has a section which considers potential fence options.
Can you direct us to the page?
Yeah, so that's page 16 of the heritage assessment.
I'm struggling to find this. This is in the application as notified. Is that what we're looking at?
No, because I think it came through at section, I think Mr. Miller's proposal was report was section 92.
Right, I think I have it now.
Yeah.
Sorry, and then which page did you say?
16.
Right. So figure 10.
Yes, sorry, so figure 10 is what I'm suggesting. My understanding is that the condition that's proposed would also allow figure 12 to be constructed.
Okay.
So my concern with figure 12 is that I think potentially, and I appreciate that the condition does talk about weathered timber, but the potential is that if figure 12 was constructed, it could have quite a suburban appearance and a very regular appearance, whereas I believe that figure 10 with the stacked schist with vertical coping, and that's in part due to the vertical coping, I think, on top, can have a much more sort of uneven, less regular appearance, much more in keeping with the rural area than the option that figure 12 could have. So that's the logic of my recommendation there. And the only other point which I haven't got on my notes was that I did suggest that, though, given that that could provide quite an unrelieved appearance when viewed from within the site, in my memo I did suggest that some landscaping take place on within the site against that wall to break its apparent bulk and length.
By landscaping, you mean planting. So we would then have, what have I got? I've got a post and rail planting, wall planting going from 67 into the site.
That's correct, yes. And I appreciate that seems an awful lot to have, but equally, the wall does have a very close relationship with the historic heritage buildings, and clearly could very clearly impact upon their existing setting. So that was it for me. Thank you.
Thank you. Any other questions of Mr. Knight, Commissioner?
I don't think so. Thank you, Mr. Knott. That was very comprehensive.
Thank you.
Yes, I think that's why I think we're signaling we'd like to see where the applicant lands with what they'd like this wall to be, because I think that's something in both our minds is exactly what that relationship between that wall is and the existing thing on site. Okay, thank you.
Thank you.
Thanks, Mr. Knott. Ms. O'Connell, obviously you sat through a day and a half, you've given us your 42A recommendation. Obviously now a chance for you to respond to the evidence you've heard from both the applicant and the submitters, and obviously, perfect opportunity if you want to change your recommendation. It's a perfectly acceptable course of event for you. Really over to you about what you'd like to bring to our attention and where you'd like to land in terms of your recommendation, in terms of the evidence to us.
Great, thank you, Commissioner Beattie. Good afternoon, Commissioner Baker. Afternoon. I, along with my colleagues, have also been taking notes over the last 1.5 days, which at the adjournment of today, I will send to Ms. Anderson, which she can circulate. I do note that the application as lodged and how it was considered at the time I prepared my Section 42A report, since then the scale and nature of activities have changed. The as lodged, I considered them inappropriate for the site and the existing environment in which it sat, hence my recommendation. The significant parameters which the application is now based on have clarified a number of matters, and they lie in conditions 4, 5, 6, 7, and 10. In addition, the site map provided with Mr. Giddens' evidence in chief, dated the 2nd of September, I find extremely helpful. If the commissioners were of mind to grant consent, I would recommend these plans be the plans referred to. They have clarified where the portaloos and the marquees would be located, which do change the conclusions of my objectives and policies assessment, especially regarding the effects of those marquees on the extent of place in the heritage setting. I echo what Mr. Knott has just referred to regarding the traffic effects in condition 34. I appreciate that the eastern site access is the most appropriate for larger vehicles, except this does enter exactly into the extent of place. So whilst that condition 34 enables traffic effects to be considered as less than minor, that then results in corresponding adverse effects on historic heritage. I noted yesterday the commissioners would have liked me to confirm my thinkings behind condition 39, which is the planting condition. And that was based on my site visits to the site, which is 15th of August, so middle of winter. And I noted that that area was sparse. I do know that in the plan dated 2nd of September, that area does look like it's vegetated, and I think possibly it's just different times of year. In that planting condition, the intention was for planting to be from the eastern access along to the boundary of 67 Fairgrass Flat Road, and for those to be possibly evergreen, so that the acoustic fence would be sheltered from vehicles passing through. I do know the concerns raised in my 42A report were around the bunching of events, especially in those warmer months. So I do appreciate that those 12 events per annum that will run until 11 p.m. have been mitigated to the extent that there will be 4 of these per month. However, there are 13 weekends in the months of December, January, and February. So they could still have 12 events held almost every single Saturday over the summer months. So it doesn't, whilst there might only be 4 a month, you can still have them in the summer. And it's a great time of year down here. You could definitely see why they would want to have them in summer rather than in August. I agree with the applicant in that the smaller community-based events such as historic appreciation site visits and the like, those are likely to be innocuous. They're likely to generate less than minor adverse effects, and they are supported by the objectives and policy framework of Chapter 35. However, fundamentally, the conditions as proposed generate uncertainty in regard to my assessment effects and the mitigation of effects. Turning back to those low-key community events, both Mr. Buckham and Mr. Giddens have stressed that the site will be used for these low-key events, heritage site visits. But we, as a number of people have said today, the conditions as they're drafted currently enable the marquees to be present 300 days of the year and 100 events per annum with 150 guests. My concerns regarding the enforceability of conditions relate to the practicability of a council liaising with the nominated events manager in the event that this person changes event to event, especially in the instance that a 1 6-hour event is held and another 6-hour event is held, and that's possibly 2 different events managers. So my conclusions in summary, as the conditions are drafted, my recommendation does not change, mainly because relating to amenity effects, the effects are unable to be proven to be minor, as they don't provide certainty that adverse effects on amenity and heritage are able to be mitigated. I am happy to answer any questions.
Commissioner, I've got some, but you can go first, Commissioner.
Well, the first one that springs to mind is you commented on the large vehicle accessing the Eastern Accessway. And obviously we've heard from Mr. Hewland on this, so we understand his point of view, but you've said it has effects on historic heritage. So what are you recommending?
I would recommend a condition that required the vehicles using this access to park and locate outside of the extent of place, because currently there's none of that. There's nothing of that like.
Thank you. I do have some other questions for you, but maybe you go ahead, Mr. Commissioner Beattie.
If I understand what you've just said to us, Ms. O'Connell, are you saying that if the conditions were worded in a different way to give some more certainty, potentially that would address your concerns?
That is correct. By and large, I see some disconnect between what Mr. Buckham and Mr. Giddens have said, that the site, they want to use the site for plunket visits, for the school coming to look at historic heritage, to appreciate the site, yet we need 88 of these per year, with the 12 events being, the nighttime events, part to 11 p.m. If there was a certain number, probably a high number of events each year that was certainly going to be used for those innocuous events, then I would see no reason why this couldn't be granted. It is the uncertainty that there's, as I've said, that there can be 300 days of marquees with 150 people and 100 events. If those were lessened and everyone, including submitters, had more certainty about when those were happening, the effects could be mitigated.
Thank you. Back to you, Commissioner. I think we're going to have a bit of a break after this. The Commissioner break, and I decide our way forward from here. Back to you, Commissioner.
Sorry, I'm just pulling up your 42A, Ms. McConnell. So I think you've addressed all of the matters that I had questions on, and you've addressed the changes. And I think really it's that over what conditions would you like to see, or what conditions could we put in, or could the applicant volunteer potentially, that would alleviate your concerns? So I understand that you would like a number of the events to be of less scale, so maybe no marquees, maybe less people, that kind of thing. Mm-hmm. Yes. How many events would satisfy you?
There's 88 events that we're talking about, because the 12 can be the nighttime events. I'm just having to do some math.
I know I'm putting you on the spot, but it's kind of important, and it's probably important for the applicant to understand where you're landing on this.
Absolutely. I'm just going to do some maths, if that's okay.
That's okay.
I'm thinking 88 minus 50 is 38. Divided by 52 equals possibly ballpark 50 events per year would be those no marquee community events designed to appreciate the historic heritage in the manner that the applicant has explained is desired by the applicant. Those remaining events per year possibly spread out, acknowledging that the site's unlikely to be used over winter, but to give those residents a certainty as to how many events will be per month of those more commercial in style events there where alcohol is served and marquee is up, that for hearing the submitted evidence, those are the ones that generate the adverse effects that have been submitted on.
Okay, thank you. That's very helpful. The only other question that I really have still is the wall. So is it your view that it's not a permitted activity to erect a fence on that boundary?
That is correct, because it's in the extent of place. The extent of place goes to the boundary, that purple line in the PDP.
Yeah.
It's blurry, it's not helpful, but that's how I see it.
Okay, so the owners of 67, they could erect a fence on their side of the boundary if they wish to, but
they could on their side outside the extended place up to 2 meters would not require resource consent.
Okay. So in terms of views from a public place, there's a permitted baseline for a fence to be in that location.
That's my understanding.
But in terms of views from the, in terms of views from 67, that would be a choice that they are in control of.
Yes, that's correct.
Okay. Okay. Thank you. I don't think I have any more questions.
No, I don't
actually.
either.
Thank you.
I think what we'll do is we'll just stand adjourned for about 10 minutes or so, and Commissioner Baker and I'll have a bit of a chat about the way forward, and then we'll come back. So why don't we come back about 12:35, just give us a bit of time, and then we'll come back and we'll discuss about how we'd like to proceed from here. Picking up what I've signaled before, but we might just add something more to that part of that discussion. So we'll come back at 12:35. Thank you.
Thank you.
All right, everyone, I've just seen if everyone's back. Ms. Vold, Ms. McDonald, and Ms. McConnell. Are you all present in the room, the virtual room?
Yes.
Yes,
Yeah.
present.
Thank you. All right, thank you. Thanks very much. We've had a bit of a chat amongst ourselves, and thank you very much for your forbearance there. Clearly, in terms of those summaries, I think by tomorrow afternoon, 4 o'clock, to Ms. Anderson is more than enough time for that stuff to come through. So then Ms. Anderson can then circulate those round. Is that all right with you, Trish? Send those round after 4 tomorrow afternoon?
Yes, that'd be great. Thanks, Lee.
Okay, so just confirm. We'll back this all up in a minute. I'll write this tonight and send it all through so we're all on the same shonk sheet. So summaries from Ms. McDonald's teams, the council's team, summaries to Ms. Anderson by 4 p.m. so she can circulate those before the close of business on tomorrow, the 21st. Ms. Vogt, how long do you, I mean, we've signaled that we'd like to see the details of this wall and actually how it plays out in light of what we've heard over the last couple of days. How long do you think it would take you to do that, and also to provide us with some details of the marquees?
I think the details of the marquee is we can do that quite readily, and we can address that in consent conditions as well. The wall, we actually haven't had an opportunity to speak about that, and I guess it's the level of what you're wanting to see in that regard. Is it a more of a conceptual kind of a design, and and I guess it's whether it's a heritage advisor matter or something. Whether we need engineering input.
No, it's not engineering. I think
well, that was one of the aspects of resolving the design of the wall to the final design, sort of to resolve that post consent. Is that if you're talking about a stacked schist wall, as opposed to something else, what might, for example, be a schist clad wall, then you are going to probably need some engineering input on that. And so those are the types of things that we were really resolving to ensure that we could deal with those things subsequently. And also one of the reasons for not supporting solely a stacked schist design, that there are other factors to consider here. So just in terms of timing, I would need to speak with Mr. Miller, and I haven't had an opportunity to do that, but I think we'd certainly want a week. And
well, I was going to suggest at least 5 days.
More. Yes,
10 days,
maybe 10.
I'm cognizant that I don't want to, prolong things. We're both very cognizant of that. So if we say 10 for argument's sake,
I think that yes,
that would also give you an opportunity to talk to the council and potentially Ms. McDonald, if you want to engage in this, and we can set a time frame for conditions. Again, we haven't come to any view on any of this. I want to make that perfectly clear on behalf of Commissioner Baker and myself. But that would give an opportunity for, and we could set timeframes in here so that the council could have a look. You could spend, say, 5 working days as well, coming out with your draft conditions, circulate them to the council and circulate them to Ms. McDonald's team, and then they could come back with areas of agreement or disagreement, and that could be circulated as part of that package with the marquees and the wall. And if we said 10 working days from tomorrow, let's just get the dates out, get my calendar here so I don't make a fool of myself. We're talking the 4th of October. Then, even though I'm actually on leave, I'm happy to talk to, I'm actually in the US then on holiday. I'm happy to talk to Commissioner Baker. We'll just figure out the time zone differences to decide if we need any, and we also want to make it clear that if anything that comes out of these commentaries from the parties that are, beyond and introducing new evidence and that stuff, we will then make a decision whether we need to call a hearing again or we're happy to proceed. So after that, we'll send in a minute. And if we do, so say for argument's sake, we do need to come back and give for everyone a right to respond to those things, we'll set out the timeframes for that. If we don't, would 5 working days after that time be enough for you to do your right of reply?
So just so I'm clear, is that is the intention here for us to circulate conditions within 5
conditions,
and then for parties to come back to us?
Yes, to you with the
Five
areas of
days.
disagreement. And I'll say, so if we gave, say, 5 working days for you to circulate to Ms. McDonald's team and to the council's team, they will then have 3 or 4 working days to come back to you, so you don't get held up. And if they don't respond, they don't respond, and that's perfectly acceptable. They may not want to respond, but I think Ms. McConnell probably will, in light of what she said.
We would certainly be looking to work with Ms. McConnell in formulating the conditions.
And Ms. McDonald, may or may not. That's totally over to her. And so we'll say that 4 working days, so that gives you time to collate and put them all together. We'll say 3 working days, I think is enough. Gives you 2 working days to collate that, so that you give back to Ms. Anderson by the close of business on the 4th, the wall, the marquees, the conditions where there's areas of disagreement and disagreement between the parties. And then we'll meet on the 5th or sometime around that to decide if we need to reconvene the hearing. If not, we will say 5 working days after that, so around the 10th of October. And I will work through the fine-grained detail tonight when I send it out, but around these timeframes, your right of reply can come in. Does that sound acceptable to you?
Yes, it does. Just with my right of reply, if that could perhaps be the end of that week, which must be around about the 14th. I don't have a diary.
Actually, when I come back into New Zealand, so that will work out perfectly well for me too. Ms. I'll just check. Ms. McDonald, are you comfortable with that?
The process, absolutely.
Thank you. Ms. McConnell, are you comfortable with that?
Yes, thank you very much.
All right. So on that basis, we'll stand adjourned. I'll confirm these in a minute tonight and get Ms. Anderson to send them around. But basically, the first key thing is that Ms. McDonald and Ms. McConnell, you send through your team's summaries that we've gone over, and Trish can set those around tomorrow afternoon, so they all get to everyone before 5. And then we'll work on that time frame for the 4th, and potentially we'll meet and decide if we need to reconvene or if we can box forward with a right of reply. Okay, thank you very much. I'd just like to thank, on behalf of my colleague, Commissioner Baker, the convenient way the hearing has taken place. And again, our apologies that we're on Zoom. Just in the council's defence, obviously not working for the council, but in their defence, that decision came through so fast and we couldn't find a date, and we all prefer to be in person. And I know the council's going back to I think they've only got 1 left on Zoom. They couldn't change either. We'll all go back into person. So I'd like to thank everyone for their time and the way the hearing's taking place in a very professional, collegial manner. So on that note, I'd like to thank Ms. Anderson as always for her time and support to us. On that note, we stand adjourned, and we'll be in touch if we need to reconvene. Otherwise, we'll box on from there. Thanks very much for your time, everyone.
Thank you.
Thank you.
Have a good afternoon, everyone. Bye.